like to call the meeting to order and introduce myself. I'm Laura Alarcon. I'm Chief of the Bureau of Security Investigative Services. Please note this meeting is scheduled to be conducted in accordance with the agenda as has been noticed. However, by approval of the committee, an item may be taken out of order if necessary. Additionally, this meeting is being webcast via the internet. The webcast can be accessed via a link on the Bureau's homepage. Please note that due to circumstances or resource limitations beyond the committee's control, there may be parts of the meeting that may be preempted. However, we're not anticipating that at this time. So beginning with item 2 on the agenda, we'd like to swear in the reappointed members to the committee and the newly appointed committee members. Those members are Simon Cruz, Jr., representing the Bureau Firearm and Baton Training Facilities, Marcel Egley, representing the repossession industry, Sandra Harden, representing the locksmith industry, Matthew Lujan, representing private patrol operators and security guard industries, Tim Westfall, representing the alarm industry, Deputy Douglas Lee with the Law Enforcement and Homeland Security with the Governor's Office of Emergency Services. He will be serving as a public member on the committee. Lynn Moorfeld with the California Hotel and Lodging Association, serving as a public member. Nancy Murish with the Congress of California Seniors, serving as a public member, and Captain Todd English with the Ventura County Sheriff's Department, serving as a public member. And administering the oath of allegiance this morning is Department of Consumer Affairs Director Awit Kadani, and I would like to take a minute to welcome him to the meeting. Thank you. Thank you. Absolutely, please do.
Good morning, everybody. Now that I'm properly caffeinated, would like to say a few words, and then we can get started with as I've said regarding other advisory committees under bureaus in the Department of Consumer Affairs, these positions are the true representation of public service. This is what it's about. The spirit of these advisory committees is picking the best and the brightest from the consumer side, from the licensee side, from law enforcement, from local government, from experts, so that they can advise policymakers on the latest trends of doing things and how to properly promulgate policy. This is public service, and I want to be real clear. What you put into it is what we get out of it. This is a very important post, and on behalf of the administration, I want to thank you profusely for what you're doing. This is very important. So with that, are we all ready? Housekeeping, what I'm going to do is, as we stand, raise our right hand. I'm going to say a few sentences, and then we will continue. You can repeat after me. So the part where it says your individual names, I'm going to say state your name, and all of you just state your name in that part. Is that okay? Excellent. So, Chief, with that, I'll have I'll have everybody taking the oath stand. We'll raise our right hand, and we'll continue.
Thank you.
Solemnly swear
That I will support
and defend
the
all enemies,
foreign
foreign and domestic, Constitution of the United States
and the Constitution
Constitution of the State of California.
that I
take this obligation freely
Well and faithfully discharge.
Congratulations. Thank you. Thank you, Director.
Oh, absolutely, Chief. From a administration standpoint, how would you like for me to, do you want to have each individual committee member come down and sign, or do you want to take care of that later?
Are the forms currently signed by you?
Not yet.
Okay,
I will.
we can go ahead and get the signatures, and then what we can do is take them up to exec office so that they can be completed with your signature.
Very good. Then I will leave these with.
Okay.
Excellent. Thank you for your time.
Again, I would like to congratulate the members and thank you again for volunteering to serve on the advisory committee. I'd like to now begin by having the roll call so that we can establish a quorum.
Simon Cruz.
Here.
Marcel Egley. Sandy Harden. Matthew Lujan.
Here.
Aaron Riley Parker.
Here.
Tim Westfall.
Here.
Todd Inglis.
Here.
Douglas Lee.
Here.
Lynn Stephen Moorfield.
Here.
Nancy Mirisch.
Here.
Javier Gonzalez. I have 10.
We have a quorum. I'd like to now note the official start time of the hearing, which is 10:03. So I'd like to begin. I know I've said a lot, we'd like to begin, but let's take a couple minutes to stand and say the Pledge of Allegiance. Okay, so we're going to take up item 4 now, which is approval of the draft minutes from the April 7th, 2016 meeting. Do I have a motion to adopt the minutes?
Make a motion that we adopt the minutes from the April 7th, 2016 meeting.
Do I have a second?
Second.
Do I have any questions or comments from the committee regarding the minutes? Do I have any comments from the public regarding the last meeting minutes? Seeing none, the motion before the committee is to adopt the minutes for the April 7, 2016 meeting. Please call the roll.
Simon Cruz.
Aye.
Marcel Egley. Sandy Harden.
Aye.
Matthew Lujan.
Aye.
Aaron Riley Parker.
Aye.
Tim Westfall.
Aye.
Todd Inglis.
Aye.
Douglas Lee.
Aye.
Lynn Stephen Moorfield.
Aye.
Nancy Mirisch.
Aye.
Javier Gonzalez. Sorry, he's not present. My apologies. 10.
that-
So
10
we
to
have
0.
10.
The motion is adopted by a vote of 10 to 0. So it takes us to item 5, which is my welcome remarks, as well as an update of what's been going on at the Bureau since our last meeting in April. As housekeeping, both the agenda and the handouts are available in the back of the room. And I'd like to take a couple minutes here to have Bureau staff stand up and introduce themselves.
Hi, I'm Andrea Daly, and I am the Bureau's ombudsman.
I'm Jennifer Munoz, and I am a policy analyst.
So, thank you. I'd like to now talk a little bit about Bsis to provide an update of where we are. So the Bureau's coming up on its 6-month mark, having launched into the DCA Bsis system. As noted in the April meeting, the Bureau adopting Bsis was a tremendous undertaking, and I'm very happy and proud of the Bureau's successful transition into the new system. With Bsis now fully operational in regards to the Bureau is now switching gears to refining the Bsis platform as it relates to the Bureau's operations. This entails identifying and making modifications and enhancements as the Bureau's understanding of the system functions relative to our business practices grows. One such example of this is the suggestion that was raised by a committee member during the April meeting about having applicants who apply for licensure via Bsis to receive notification to their dedicated email account advising them of the actual issuance of the license and the license number. This automatic notification would be similar to the email that applicants receive upon the submission of their application. And we are now exploring the system enhancement in this regard with the hopes of having something in place potentially by the end of the year. Another enhancement that we're looking at, and it's been based on feedback that we've received, is looking at the Bris Verify License feature that's available on the public website. The users of the search engines now are being randomly selected through, and this survey is going to continue on through the end of August. Individuals are being randomly selected to ask to complete a survey to provide feedback of what they feel about the current search features and where there might be possibilities for improvements, all for the one purpose of enhancing the service. Lastly, we are working on enabling company applicants to submit more than one business license application through Bris. Currently, only the initial company application can be submitted through the Bris platform. With this enhancement subsequent, so an individual entity who may hold more than one bureau-type license would be able to do all of the business transactions through the Bris platform, as opposed to the initial one being submitted through Bris and then the subsequent one having to come through a paper format to the Bureau. Again, the hope is to have this additional enhancement sometime in place sometime by the end of the year. I'd like to talk a little bit about what the Bureau is seeing in regards to the actual Bris transactions. And you know what? I just realized we have some new members of the committee, and perhaps maybe I need to step back a minute here and talk a little bit about Bris. So basically, Bris is a relational database that the department has had in place for about two and a half years now. And what I mean by relational is that the licensing system is interrelated to the enforcement system so that when we are carrying out our regulatory activities, the two systems communicate. Prior to the Bureau being on the Bris platform, we utilized two separate distinctive systems, one that was involved for licensing and one that was involved for enforcement, which from a regulatory perspective created some disconnects that could affect potentially some decisions that were not favorable in a licensing arena, which required additional staff to be involved in the decision-making of every license that's looked at. With Bris now, we have, since the systems now are on one platform and they communicate, if we get an application, there's something that may be happening with that applicant in the enforcement arena, the licensing individual will automatically get notification of that fact. And that just enhances the Bureau's ability to look at overall the applicant's fitness for licensure. We have the two systems connected. The Bureau launched into Bris in January of this year after having had Bureau staff, a total of 5 individuals dedicated to the Bureau, developing the Bris platform for the Bureau for almost 2 years. And the complexity of Bris, the complexity of the Bureau with having 27 different license types, including company license types, really pushed the parameters for Bris in many ways that had not happened with the first launch. And so when I talk about enhancements, it's because while the Bris system has been in place for many of the boards within the department, primarily the allied health boards, it bringing the Bureau and our business processes to the platform required additional reconfigurations of the system. And so in many ways now, the Bris is being tested in areas that it hasn't had to be in the last 2 years. And when we look at these system enhancements, inherently, when a platform is being developed, yes, you look at your business processes, you look at the theory of what you believe it should exist like in this new platform, and we do testing. I mean, we never launch anything without testing. But the fact of the matter is you really don't get a flavor, a taste of everything until it's in production. And now with the production end of things, we're seeing, you know, there's opportunities to improve. There's opportunities to tweak. There's also, in fact, there was, I mean, Clarissa, how many transactions existed in the Bris platform? Over 1,000, 1,800? So would it be safe to say about 1,000 transactions in total for everything that we do with every different license type, initial, renewal, or? So keep in mind, when we have the BSIS SMEs involved with the developing of our, of the platform based on our business processes, and we're working with IT folks in developing it, everything's theoretical. And sometimes these different transactions got documented into a profile report, which was about several inches thick. Some of the transactions are not occurring exactly how we envision, but none of these transactions have been so off base that the business processes have stopped for the Bureau. And in that sense, we have been very successful, which is why my introductory comments was I'm very proud of our transition and the success. But there's rooms for improvements, and there's room for looking at the tweaks of things that aren't quite working the way we intended. And in reality, the volume of applications the Bureau receives on a monthly basis, we receive between initial and renewal and all the license types, almost 17,000 applications a month. The entire Bureau only has about 60 individuals on staff. So do the math. We have a high volume of work. We have staff, a certain, staff bandwidth. What we're looking at now with Bris is how can we utilize Bris to make us more effective in what we do? And so when I'm saying talking about enhancements, talking about improvements, that's exactly what I'm referring to. Does that help a little bit? Okay. So in regards to Bris, we launched mid-January, and the total number of apps that the Bureau has received in the Bris platform has grown about 3% since April. In the month of May, we received a total of 8,767 registrant and company apps, both in initial and renewal platform, almost like a 50-50 split. That total number comprised about 56% of all applications the Bureau received in the month, because we received close to 16,000 licensing applications. So 50% in a Bureau, in a Bris platform is good, but again, we have limited staff bandwidth, we can do better. And so we're going to be looking at how to get the word out on getting more participation. On average, when I look at these numbers, 80 to 85% that are using the Bris platform for initial application are security guards. It drops significantly after that. When we're looking at the registrant applications for the month of May, as I said, we had about 81% for initial guard were on the Bris platform, and about 3,400 or 53% of the renewals by guards were on the platform. That's almost a 30% drop, and the question would be why? When there's so many features that Bris affords the individual on timeliness and the renewal, we need to be looking at that. Alarm agents, their number was only 25% of the total number of applications that we received in the initial environment, and less than 50% on renewal. Again, why? We need to work with the associations, get the word out more, because there is a tremendous time difference between applying through Bris and getting licensure than it is through a paper environment. Proprietary officers, we're looking at about 75% initial, 35% renewal. Again, significant drop. The Bureau's exploring why the disparity. The locksmith industry for initial employees, we're talking about 78% for initial application coming in on the Bris platform. But when we look at renewals, that's dropping down to around 30%. The firearm permits, only 24% of all firearm permits received in the month of May were on the Bris platform. And of the renewals, only 30% were in a Bris platform. In regard to company stats, that number drops even more. So private patrol operators in the month of May, less than 10% of the applications were received came in a Bris platform, and only 35% in a Bris platform on renewal. Private investigators were by the lowest of the companies. They only came in at 7% of the total number of applications that received in the month of May, and 27% of the renewals. Alarm companies are running about 48% for initial and 30% for renewal. Qualified managers in the alarm industry were running about 38% for initial and 35% at renewal. In the repossession industry, only 1 out of 4 of the applications, or 25%, came in on Bris, and 43% were in the renewal arena. We did not receive any applications in Bris for any qualified managers, repossession qualified managers. And we didn't receive any company locksmith applications in the month of May in Breeze. And of that amount, we only got about 30% in the renewal arena. Firearm training facilities and baton training facilities were pretty much at the same playing field. About 1/3 of the applications received in the month of May were on a Breeze platform. And when we talked about renewal, it was about 45 to 50% on the Breeze platform. Training instructors, only 17% on initial and less than 40% on renewal. So the question that the Bureau is looking at is, given all the benefits of Breeze, you can pay online. You don't have to have your app go through the cashiering office, which automatically adds 2 weeks to the application processing times. The registrant applications, they're built in such a manner that the submission of the application will not result in a deficiency. When we're looking at paper apps, and I'll be talking about that a little bit more on the licensing update, we have about a 30% deficiency rate on paper apps. So you get it on a Breeze platform, and the platform is set up that it will not allow the application to transmit unless everything's complete. So you're minimizing deficiencies, which delay licensure. You're paying online, which cuts back 2 weeks. Why isn't Breeze being used more? And the Bureau is going to explore and reach out to the associations to see what we can do to get the word out, to try to get more individuals and more companies maybe aware or maybe comfortable. Is the issue not knowing about the system, or is the issue somebody goes onto the system and finds it, I don't want to say intimidating because it is very user-friendly, but for whatever reason, once they start the platform, they opt for a paper app. So we want to tout more. I'll give opportunity at the end, yeah. Want to tout more the benefits and try to see what we can do to get the word out. So that's the Breeze update. I saw a question over here, Nancy.
Does the Breeze format work on smartphones, or has it been evaluated on that end? I don't know, but one question that comes to mind when you're having the renewals be lower than the initial is, are people that are going into an employer's office sitting at a computer to do that initial application, but then there is a very significant part of the population that just uses a smartphone type of application as their computer, and that just made me question whether maybe that was part of the low participation. Yeah.
That's an excellent question, and it's not one that I know the answer. Any of the Breeze SMEs, are you aware of its exists? I know that you can use the phone to access the internet and get to the internet to get to the platform, but the question is, does it function off of that?
It's not designed to function properly with a smartphone. It's designed more for the computer. So that may be something that we want to look at.
Steve, in terms of the renewals, are you communicating to the renewals electronically via their email address, or are you sending something to them in the mail?
They get something in the mail that gives them.
I'm just thinking that if you communicated to them initially via email, that would go to the online process.
And that's an excellent comment. We are looking at updating all the initial application forms and the instructions to talk about the functionality of Breeze for renewals to see. Again, we're exploring all these options now. We've been in production for Breeze for 6 months. Now we're making observations of the data, and now we're looking at what does this mean? What can we do? So all these are really good comments and feedback, and these are all the type of things that we're looking at. Can you come up to the mic? You're on the phone.
So if I remember correctly, the renewal forms that are mailed out actually have information directing them to go to Breeze, to go online and renew online. Also, that work authorization that's going to be coming out eventually regarding sending emails out. I believe there's one in there that's telling them also your renewal's open, your renewal transaction's open, your license is going to expire. So I believe there'll be an additional email going out with that same work authorization you were talking about earlier.
So just to kind of provide background, that is the enhancement that I mentioned early on, where we're setting it up so that when, upon initial licensure, the individual gets an automatic email sent
Correct.
saying that they're licensed, and now it will also be an automatic email when the renewal window opens up for that license type.
Right, it's either that or when it's getting close to them expiring, it's gonna be like a reminder, like you have so many days before your license expires. Versus the renewals normally are generated 90 days prior to expiration and then go out. But I haven't looked at the renewal forms lately, but I know we had information in regards to, go to this website, here's the link, so, and it's telling them, directing them to go online and pay their renewal fee. And it's easy and it's instant, because if they, as soon as they get their payment in and there's nothing else that's required other than their payment, it's instant and it updates their license status and their expiration date right there and then. So then for those that can work with like a web printout, they could just print the web printout.
So just kind of in summary, what's happening now is we're seeing the data, we're looking at it, we're trying to figure out what more we can do to get folks onto Breeze.
I don't know if you can do this, but can you make it economically beneficial for the applicants to utilize the Breeze system as opposed to the paper? I mean, it takes a lot more effort. No, you're...
So that would be legislation to change, because everything is established in statutes and regs on what we can charge for an application. So, and it also could result in disparate treatment and,
Okay.
yeah. So.
I'm just trying to figure out some incentive so that we get them
Right.
away from the paper to go the electronic. It's a much better way for them
And I
and
think-
for the Bureau.
I think what really the Bureau's looking at is what we need to kind of find out, what are some of those barriers? I mean, I know that some of the issues are the credit card, and individuals may not have a banking account, some of the licensing population, but there are the ability to use prepaid cards. And so I don't know, maybe we need to get more word out there that the prepaid cards are an option. And so all I guess what I'm leading up to is we're just barely 6 months into this thing, if even that. And we're seeing great participation in the guard industry at initial. We're seeing marginal participation in the other areas. We know that historically the guards have had the online professional licensing system in the past, so they've had a more historical experience with the online application that has not existed in these other industries. This is the first time this automated application process is touching them. So we're exploring, and I'm hoping by the time we come back for our next meeting, which I'm not really sure, because we're going to be potentially one of the items on the agenda is whether we're going to keep the current schedule or modify that slightly, but neither here nor there. Hopefully by the next meeting, I'll be able to talk a little bit more about what the Bureau has identified as potentially some of these barriers, or maybe they're just informational issues that we need to enhance, and we'll see some numbers going up.
Question, Chief. On Breeze, when an applicant is either applying or renewing, and they have to email a document, a supporting document, I think one of the barriers there is maybe they don't have it, because if they have to scan an email and they don't have a scanner in the office, that's another barrier, because in my office, there's 8 suites and I'm the only one who's got a scanner.
Right, and that would be true for the firearm permit, but the other one should be able to be automated, and there's not any other form. But you're right, that we understand that, but when we have to have firearm instructors certify the requals, there is no other way of doing that other than to have the paper signed and have that uploaded. But again, it's all these things that we're exploring. So continuing the update, thank you for the question. Continuing the update, in regards to the licensing unit, as I previously mentioned, we receive anywhere from 16,500 to 17,000 applications monthly, both initial and renewal. And then when you start adding on the name changes, the address changes, the duplicate requests, we're adding additional 600 to 700 pieces of paper that are hitting the Bureau on a monthly basis. This is a tremendous amount of work given the number of staff at the Bureau, and this is why Breeze use is so important. In regard to registrant applications, the Bureau's current processing times is running around 8 weeks. Now, that's pretty much where you want it, where we have said no more than 8 weeks. So 8 weeks from the date of submission. We'd like to get that down to 6 weeks, but again, we only have so much staff bandwidth, and 30% of the applications we receive in a paper environment are deficient, and that inherently takes longer to process. With Breeze, if the information is entered by the applicant, the name, the social security number, the date of birth, if all of that information matches the information that was entered by the live scan operator, and as background for new members, the Bureau's licenses require that that individual submit fingerprints for the purpose of a criminal history background check. In the state of California, that's most frequently done through live scan machines. So if we have an applicant where that applicant has done the due diligence in not transposing social security numbers or date of births when they enter the information in the Breeze. Similarly, if the live scan operator has not done any data entry errors, if the name matches in the live scan exactly how the applicant put it in the application. I mean, if you add in Hispanic, and I'm Hispanic, hyphenated last names, and it's not hyphenated the way the live scan operator, those are going to be deficiencies. But let's just say we've got everything clean in the manner the way the applicant entered the information, the live scan operator entered the information. If the applicant has no criminal history, we're not encountering any Department of Justice or FBI delays in providing the Bureau information, we actually have had license issued from the date of application in a couple of days. So again, we're looking at 8 weeks paper processing time. We're looking at days processing time if an applicant is submitted appropriately and accurately in Breeze. A minor data error, if that applicant has transposed 2 digits in the social security number, again, entered a name, the difference from the name that's on the live scan, they're now going to sit out there. There's not going to be anything automated about that application. It's going to require staff to go in and touch the application and manually sync the criminal history response with the application. And we're talking now, if that is the case, 6 to 8 weeks. And one of the reasons the Bureau is not able to touch these applications when they're in this, we call them kind of a deficiency mode, is that if we go in too soon, the majority of the fingerprints not matching may be related to a delay, or it may be related to criminal history that there's still, DOJ is still gathering the information. So from a staff resource perspective, we are not exceptions. We're not going to be touching these exception applications for at least 6 weeks to let the dust settle, and then we're truly dealing with deficiencies. So again, this is one area where the applicant has total control in ensuring that they can get their license issued timely. As I mentioned earlier, about 30% of registration applications are deficient in paper world, and probably about 20% are having problems when they enter into a Breeze environment because of inaccurate data entry. To avoid deficiencies, the Bureau encourages and Breeze to take time and care in entering all the requested information, look closely, coordinate closely with the live scan operator to make sure that the information that that operator is entering aligns with what's on the application. On a paper application, they need to use the current form. And I know that individuals have, we've received applications, as I mentioned, in the last dated 1998, 2005. I mean, we have updated the applications due to changes in law, most notably the conviction questions that are required to be answered on the application. I don't know where applicants are in the paper arena are getting older applications, but they will be deemed deficient because they need to align. The application needs to comply with current law. The other thing, they need to take care in entering the information. I personally have processed applications and I have seen handwriting that is totally illegible. I had no way of deciphering what the individual's name is. I've also had incomplete addresses. I saw an application where the only thing in the address was the residence number, 45. So we didn't even have a means to send that individual a deficiency letter to say, your application's complete. These are all areas the applicant has complete control to ensure that they're getting their license as timely as possible. We are also running about 8-week processing times for renewals. By law, all registrants are required to submit their renewal application at least 60 days prior to expiration. That 60 days was built in by the legislature, recognizing that the Bureau's average processing time is 60 days. We routinely see applications come in 2 days before expiration and expecting it to be renewed before the license expires. That's not going to happen. Again, these are areas where the license holder, the renewal applicant, has absolute control to help ensure that they get their renewal done before expiration. The other thing that we see very commonly is, I think, the Hail Marys that come in where the law says that if you submit your application after expiration, you can renew for a period up to a certain time, up to 30 days for locksmith employees, up to 60 days for the other registrants with a deficiency fee or a delinquency fee. But if that delinquency fee is not included, now the individual's past expiration, we're having to issue a deficiency letter saying you did not submit sufficient payment, and we're playing the lotto on whether all this is going to transpire to get the payment back before the 60-day window has lapsed, and now the law says you can't renew. So it is surprising how many number of situations that we get on a daily basis. I think staff are doing this because a lot of times when they're staffing phones or they're dealing with emails or escalated issues, there are times the Bureau has created errors, data entry errors as well, but the vast majority of time, these things were in the control of the applicant. So again, industry folks, anybody, just get the word out. This is an area that you can really, really help yourself in getting your initial license and your renewal license done timely. The processing time for company applications varies depending on the deficiencies and the time it takes for the individual to pass the qualifying exam. If they use Bris, it will cut down time because of the cash, being able to pay online as opposed to having to go through the cashiering office. The same rules apply for avoiding deficiencies. And I encourage anybody that's applying for a license or has questions in general regarding their prospective industry to use the dedicated email accounts that have been established on the Bureau's website. We have an account that's set up for each different license type, and you need to check it out because we use it not only to correspond with applicants on the status of the application, but we also use it to respond to questions that individuals may have regarding the Bureau laws. As I shared in April, we launched the new the new firearm permits. We separated the one firearm permit into two, one for initial and one for renewal. Both applications are now on the Bureau's website. They are more user-friendly, and the format is such that you do not have to complete all or the individual, the permit holder, does not have to complete all requals with the same training facility. And we also provided additional information to avoid deficiencies. Letters were sent out to all training facilities regarding the change, and effective September 1, 2016, only those applications will be accepted for any requal that was completed after July 1. So, adding a caliber. When we we're updating the firearm permit applications, and as a result of the current focus by the legislature on the possession and use of firearm by security guards, the Bureau noted that the process that was being used for a current firearm permit holder to add another caliber, so that enables that permit holder to work with that caliber of firearm, we found that the process that was being used by the Bureau was not supported in law, and we accordingly temporarily suspended it. After extensive analysis of the laws and regulations, the Bureau has determined that the only legal pathway to add a caliber under current law and regulations is for the individual to complete the firearm training that's required to obtain an initial firearm permit. Notably, the individual must complete all of the requirements that are specified in Section 635 of Title 16, Division 7 of the California Code of Regulations, which states that they are required, the applicant for an additional caliber is required to complete the course of carrying and use of a firearm. The applicant is required to pass a written firearm exam with a score of 85% or more. The individual is required to discharge 250 rounds, a minimum of 2 times, one for practice and one for score, and the individual must achieve a qualifying score on the range of 80% or more, a minimum of 80%. The Bureau has developed a certificate of proficiency in specified caliber. This document is supported in current law, both the Private Security Services Act and the Alarm Act, and this document will be used as the vehicle to add a caliber. Again, this certificate is based on current law. and we are in the process of getting the information up to the website. In addition, we're going to be sending letters out to training facilities. Once the new forms are available on the website, we will begin to be adding we'll begin again the practice of adding a caliber, and hopefully we will have these forms up on the website by close of business next week. So licensing takeaways is use Breeze, overall shorter processing times. If submitting a paper application, use one that's from the Bureau's website, because that will ensure it's current. Write clearly and make sure to provide responses to all requested information. If you're using Breeze for firearm renewals, remember it requires scanning and uploading a complete signed paper firearm application form. Simply completing the cursory Breeze information that's associated with the firearm renewal does not constitute a renewal application. It has to have the scanned document. And the last thing is, do not submit renewals at the last minute. It's going to increase your costs because you'll have a delinquency fee, as well as potentially impact your eligibility to renew. Any questions regarding licensing update?
Chief, quick question on adding a caliber. So the applicant would have to go through the full 2-day course and then submit this new form? No initial application, no live scan fingerprinting, is that correct?
That is correct. There won't be any live scanning, no application form. It's simply the training. And again, when the Bureau looked at this and we discussed it, we believed that the legislature intended that we needed to ensure that that individual was proficient in a firearm and additional caliber. The way staff explained to me, it could even involve changing from a, what was it, from a revolver to a semi-automatic. So I don't know. My weak area. And so the determination was made that they needed to do the full training. Since there's nothing currently in law or regulation that allows us to bifurcate that, it has to be the complete training. The Bureau is continuing to look at this, and we're looking at regulations potentially to streamline it down to just the range aspect of it. But as I said in my narrative, and what will be coming out shortly in an email blast, is under current law and current regulation, this is the only legal pathway to add a certificate at this time.
Thank you.
Any other questions regarding licensing? So going on to legislation, I'm going to briefly talk about the bills that are affecting BSIS or the private security industry, starting with SB 468 by Senator Hill. This is the Bureau's sunset bill that was introduced last year. It is a 2-year bill. That's a little bit unusual. There continues to be much discussion on one primary provision in the bill as it relates to the requirement for obtaining a firearm permit, the initial firearm permit for security guards, and whether an assessment that will need to be done to determine the individual's fitness to carry and use the firearm in respect to control and restraint decisions. Discussion still continues on that. The bill is currently on the Assembly inactive file. With the session coming close to session, the legislature is on break this month. They'll be coming back in August. The legislative session ends in August, so we anticipate very shortly what this new bill, what the bill is going to look like coming out in print very shortly, first week of August or so. So it will require an assessment to be done for any security guard applying for firearm. It'll also it'll mandate firearm training facility inspections. Within 90 days of getting issued a license, the Bureau has to go out and inspect the firearm training facility. It also clarifies the requirements for the private patrol operator, which is the employer of the security guards, to report to the Bureau any violent incident, notably the discharge of a firearm that's associated with a security guard. It expands the exemption to California peace officers regarding firearm training requirements to federal peace officers. And it also requires a distinctive disclosure of automatic renewal and alarm monitoring contract. The bill also makes numerous revisions in the fines, the fine amounts that are associated with violations of the Practice Acts and each of the Practice Acts. The next bill is Senate Bill 1362. This bill is essentially not moving forward. The bill would have allowed LA Metro Transit Authority security guards to detain individuals on LA Metro property in under specified conditions. It also would permit them to carry a shotgun, use a large capacity magazines, and basically the bill failed to get out of its house of origin by the required deadline, and the bill is now essentially dead. AB 1859 is currently in the Assembly Appropriation Committee, and it proposes various changes to the Business and Professions Code and the Vehicle Code to address issues relating to the repossession of collateral, namely vehicles. The key provisions include eliminate the terms skip tracing and assignment, and adds and defines the terms locate and repossess as they relate to the business practices of repossession. It also exempts from licensure repossession agency employees who use automated license readers to locate collateral, and it makes various other changes in the handling and inventory and storage of personal effects in the vehicle at the time of the repossession. As I stated, this bill is currently in the Assembly Appropriation. No, can't be. Has to be Senate. Second House. It's a typo. It's Senate Appropriations. The next bill is AB 2632, which is currently on the Assembly third reading file. It would provide for investigative journalism experience to qualify as an eligible experience for the purpose of attaining a private investigator license. And the last bill I'd like to talk about is Senate Bill 1155, which is currently in the Assembly Appropriation Committee. And it provides for the waiver of the application fee for individual license types to individuals who serve as active members of the U.S. Armed Forces or the California National Guard under specified conditions. In regard to regulations, the public hearing for the Bureau's firearm qualification and training regulations, which we are kind of coining the firearm simulator regs, was held on May 27, 2016. The Bureau did receive public comment on the regulations both during the hearing and in writing, and the Bureau has prepared its responses to the comment and is currently readying the rulemaking package for submission to the Office of Administrative Law. The proposed regulations to be submitted will reflect the language that was previously noticed. As a reminder, this rulemaking packet provides guidelines on the use of firearm simulators for firearm training to obtain and renew a BSIS firearm permit. Specifically, it prohibits the use of a firearm simulator for the purpose of qualifying on the range to obtain initial firearm permit, and limits the use of a simulator for the purposes of qualifying on the range to one time per each 12-month period of the 2-year term of the firearm permit. This rulemaking packet also removes the prescribed targets from the firearm training outline and instead specifies specific minimum standards for the targets to be used for the purpose of completing a range qualification. This will make the targets easier to obtain, thereby reducing the cost to applicants and permit holders associated with completing a range qualification. In regards to the new Bureau staffing positions, as a result of the Bureau's success in getting budget change proposals approved in the last 2 years, the number of our allocated positions has increased, as well as our related spending authority for fiscal year 2016-17. We are currently in the process of recruiting 2 program technicians, 2 in the licensing unit, and an analyst in the licensing unit, and 2 analyst positions in the enforcement unit. In addition, we are in the process of recruiting student assistants, and we currently have 6 permanent intermittent staff in the licensing unit and a retired annuitant. So the moral of this story is we're doing our best to round up the troops to work on those applications, all toward getting them license issued as quickly as possible. In regards to the dissemination of alarm and locksmith consumer brochures, I want to thank the committee for their suggestions made during the prior meeting, and in regards to how ideas for the Bureau getting those guides out to consumers. And in the past several months, the Bureau has provided copies to the Congress of California seniors to distribute during their senior rallies at the state capitol. And I want to thank Nancy for all your help in this effort in getting the word out to seniors. Please know that we hope to continue collaborating with Congress of California seniors on future similar activities. We also provided copies of the brochures to the California Contractor State Licensing Board, and via the board's outreach coordinator, the brochures are now being handed out during the monthly senior scams meetings held throughout the state. We also are sharing the brochure with the California Bureau of Automotive Repair, and they are now sending the locksmith activities out to their outreach efforts as well. And the electronic versions of the brochures are available both on the BSIS website and the BSIS Facebook page. Staff are going to be reaching out to the legislature shortly to see if there's an interest from legislators to have the brochures on their constituent-related activities when they do their outreach. And hopefully during the next meeting I can give you an update that this is moving forward as well. So I want to close my update with the interested parties list, and I know we have new members on the committee. So the best way to stay up to date on what's happening at the Bureau, and I cannot emphasize this enough because it really does keep you up to date, is to sign up for our interested parties list. And you can register for that email distribution off the Bureau's website. It is on the website under Quick Hits, and the link is called Join Our Email List Link. That concludes my Bureau update. Do I have any questions or comments from the committee?
Chief, I was going to mention on the Bris program, we put a link on our website for our members and for any of the repossessors in the state of California to go to Bris, encouraging them with the link that they find there to go directly there to register. And that's something that they have found helpful, just once they go to the website, because they're there for other reasons as well. But the link is there for them. And that way, if they're not familiar with Bris, or if they haven't licensed in a couple of years, then obviously when their license is coming up for renewal, if they go to our website, the link is there. And that's, we've had some positive feedback in regards to having that link and it being friendly and them being able to navigate their way.
Thank you.
You're welcome.
Thank you. Excellent. Any other comments from the committee? Do I have any comments from the public regarding any information that I just shared in my Bureau update? Seeing none, I'd like to then go to item 6, which is a discussion of the prioritization of enforcement cases. With us today is BSIS Deputy Chief Connie Bouvet, who manages the Bureau's enforcement and disciplinary review units, to provide an overview of how BSIS prioritizes its complaints and enforcement cases. And just as a reminder, this was an issue that was raised by the committee that they were interested in hearing a little bit more, so we brought it forth.
Morning. I am the Deputy Chief of the Enforcement Unit at BSIS, and I'd just like to read a little bit of how we prioritize our cases. The Bureau prioritizes cases using the public and consumer protection as the first and foremost criteria, and those cases with the highest potential for public harm are most expeditious addressed. The Bureau allocates its resources so that cases involving fraud and dishonesty, unlicensed activity, and illegal or unethical behavior are also addressed appropriately and as timely as possible. The Bureau uses guidelines similar to ones used by the Department of Consumer Affairs, DCA, as outlined in their complaint prioritized guidelines for Department of Consumer Affairs, which can be located on their website, DCA website. The guidelines have 3 priority levels: urgent, high, and routine, to guide the Bureau in identifying the urgency of the investigation, and examples of those cases involve high priority, including allegations of sexual or physical abuse, weapons violations, and felony convictions. Incident reports and notice of violation acts for such things as firearm discharge, physical altercation, arrest of a guard, injury of member of the public, which requires medical attentions, continue to remain a high priority for the Bureau. In fact, the Bureau has dedicated an email box for the licensees and law enforcement to submit incident and notice of violation reports so the Bureau can easily prioritize these cases. All incoming complaints are reviewed by a Staff Services Analyst, SSA, to determine jurisdiction and to prioritize. If the case is deemed high priority, the SSA will discuss it with the enforcement manager to determine if the case should be handled in-house or forwarded to the department's Division of Investigations, DFI. These elevation process also ensure that management can monitor the progress of these cases. Some of the situations which would require a case to be forwarded to DFI include, but are not limited to, employee safety, the need to interact with persons with known violent history, the need to visit locations known to be unsafe due to high crime rates, cases involving criminal activities, and cases that most likely will be referred to the District Attorney's Office for filing criminal cases, and unlicensed activity cases that require sting or sweep operations. DFI will provide a presentation on their prioritization priorities and complex of their investigations later today. Complaints handled in-house are assigned to an Associate Government Program Analyst, AGPA. These individuals are not sworn or non-sworn safety staff. The AGPA will interview all parties, which include complainants, respondents, employers, witnesses, etc., and gather supporting documentation, including employee records, court documents, contracts, etc. The AGPA may determine after performing the interviews and gathering the supporting documentation that cases should be handled by D of I. If this happens, the AGPA will discuss the case with the enforcement manager. If management determines that the case should be referred to D of I, the AGPA will summarize his or her findings and attach the supporting documents and forward to D of I. Complaints handled by either AGPA or D of I can result in no disciplinary action at all, and they could be education, insufficient evidence, no violation, etc. The issuance of a citation or a fine or the filing of an accusation to suspend or revoke the license pursuant to administrative hearing process. The Bureau's action in response to substantiated violations of the law are governed by the disciplinary-related provisions of the Bureau's Practice Acts, which are generally guided by the severity of the act. Citations and fines are generally for non-egregious violations and are considered as a deterrent to the prohibited act. The issuance of citations and/or fines is determined on the case facts and findings. The filing of an accusation is reserved for egregious violations or ongoing repeated patterns for non-compliance, which indicates that the individual or entity as being unfit for licensure can result in the suspension and/or revocation of the license. In 2014, the Bureau proactively began conducting compliance inspections of various industries regulated by the Bureau. The proactive work is to ensure licensees are in compliance with the various business and profession code sections, which again goes back to public safety. In May 2014, the Bureau's investigation staff began conducting compliance inspections of private patrol operators, PPOs, and training facilities. To date, the Bureau has scheduled and/or completed 235 inspections of PPOs, 97 inspections of firearm training facilities, and 39 training facilities baton. In June 2016, the Bureau scheduled and/or completed 9 inspections on alarm companies. Types of items the Bureau inspects include entity structure, business name, address, training records, registered personnel, and advertisement. Common violations that we see are failure to keep training records, changing the business name or address, changing the business entity structure, meaning they're going from a sole ownership to a corporation without notifying the Bureau and getting approval by the Bureau, or a partnership to corporation, and having unregistered personnel. So those are the focuses of the enforcement unit and of the enforcement division.
Thank you, Connie. Before I turn it over to the committee for questions, I do want to make clear that when Connie was talking a little bit about the decision on citation versus the filing of an accusation and the filing of accusation to take action on the license being reserved to egregious cases, that is a general guideline. However, the decision on any type of disciplinary action the Bureau is going to be taking is at the discretion of the Bureau, and any violation could result in an accusation. And I don't know if counsel wants to add a little bit on that.
The situation with discipline is similar to prosecutorial discretion. I'm sure most of the panel understands the concept of prosecutorial discretion. So while the Bureau has procedures and guidelines in order to manage workload and to effectively handle the volume of cases that it handles, in any given situation, if something is determined to be out of the ordinary, just because in the routine a situation would typically be expected to result in a citation doesn't mean that it can't result in discipline. Neither does that also mean that it's a defense that you got an accusation or a guard gets an accusation in one particular set of facts where something that appears to be identical to another guard results only in a citation. the level of discipline taken for any violation is not in and of itself evidence of any type of determination by the Bureau that there is a difference in the case. So going back to the concept of prosecutorial discretion, I don't want, because we have these standards, because we have these prioritizations, nobody should be misled to believe that a citation under one set of facts in one circumstances will always necessarily mean that that will be a citation, or will always mean that it will be an accusation. And it may be that in some circumstances there's no action taken, and in other circumstances what you expect to be a citation would actually be an accusation. Just so everybody's on the same page.
Thank you, Sheila. Now, do I have any questions or comments from the committee? I know this issue was of particular interest to the committee from the last hearing.
I hate to ask this, but you were throwing out these AGAP and DVI. I have no idea what that means.
So the AGPA is an analyst for the enforcement unit, and DFI is Division of Investigation.
Okay, great.
And I think the emphasis was that our enforcement unit is staff, we do not have sworn individuals on staff. If we are going to require, if an investigation is going to require to have law enforcement engage in that investigation, it goes over to the Division of Investigation. The analysts do have broad authority to conduct the investigation, but not when it's crossing into the arena of law enforcement activities.
Okay. And you were talking about taking care of the PPOs and all that. Have you started, and then you also went into alarm companies, have you started in the locksmith industry?
We have not started in the locksmith industry yet. We were doing it as a progression through the different industries, so we have not gotten to it yet.
Do you anticipate when you will be going into the locksmith industry?
I would hope by the end of the year.
Because it's really rampant on the desert right now of unlicensed locksmiths, so that's
Yeah, the
my biggest
compliance
concern.
inspections are more of licensees because we're looking at the business records that they're required to have and those types of things. So the compliance inspections are not for unlicensed activity, and so they're a little bit different. Unlicensed activity, in some arenas, we have to send over to the Division of Investigations because we need sworn officers to do the stings and the sweep operations
Right.
that we can't do. So those are things that we would refer over.
And we have talked a little bit about locksmith before, and I know we've got DFI, and I can see that Rex is not here, Eric Commander. Rex Cowart has not yet arrived. Okay. So we may have to take that item out of order. Many of the locksmith activities, because the internet is often involved, where the individual's calling an 800 number, and these things, the internet's almost by the time we start getting involved, calling and doing whatever, that number has shut down and they've now opened up. It's almost like whack-a-mole with the internet. Unlicensed activities do involve the Division of Investigation, and they are, because of that nature of this kind of behind, the veil of the World Wide Web, makes it more challenging.
And it's also they're mobile, so you don't have a location that you can go to, they move. And so that's difficult also.
Right. But the next item is going to be talking a little bit more about that. But the individual with the Division of Investigation that was going to do the presentation did advise me in a text this morning that he has a law enforcement activity going on right now that could not be changed, and so we're going to probably have to take that up after lunch.
Oh, okay.
So, but I'll ask for motion. But while we're still on this one, do I have any general questions from the committee regarding regarding BSIS and how we handle our enforcement-related activities?
Not a question, a request. May we get a copy of what you just read? Copy of that, or?
Yes, that's all right. Yeah.
Any other questions? Thank you, Connie. Do I have any comments from the public regarding agenda item 6? Seeing none, we would be going now to item 7. However, as I just mentioned, our presenter is running late, so I need to have a motion from the committee to allow us to take item 8 out of order, continue with the agenda out of order until we do have the presenter for item 7.
I'll make a motion to take item 7 out of order.
I second that.
Okay, the motion before the committee is to allow us to take item 7 out of agenda order.
Simon Cruz,
Aye.
Marcel Egley.
Hold.
Oh, I'm sorry.
I know that it seems very bureaucratic, but we got to follow because it's a motion, we got to follow the same format. So comment from the committee, comment from the public, and then a vote. Apologize. I realize it's very bureaucratic.
No, so, I'm sorry. So the motion before the committee is to take item 7 out of order, but do I have any comment from the committee regarding that motion? Seeing none, do I have any comment from the public about taking the item out of order? Seeing none, call the vote.
Simon Cruz,
Aye.
Marcel Egley,
Aye.
Sandy Harden,
Aye.
Matthew Lujan,
Aye.
Aaron Riley Parker,
Aye.
Tim Westfall,
Aye.
Todd Inglis,
Aye.
Douglas Lee,
Aye.
Lynn Stephen Moorfield,
Aye.
Nancy Mirisch,
Aye.
10-0? Okay. Thank you. And we'll remember next time. Okay, so that takes us now to item 8, which is potential revisions to the industry brochure for the BSIS Consumer Guide to Repossession Agencies. This is a handout in your packet, the draft, as well as handouts are available in the back of the room for the draft. During the July 2nd, 2015 meeting, committee reviewed the current consumer guide to repossession agencies and provided suggestions for its revisions. The Bureau incorporated many of the comments into the current draft brochure before you. Because the draft involves substantive changes from what was the existing document, we're bringing it to you today only for feedback, with the plan of making the final revisions and adopting the updated guide during the next meeting. Jennifer Munoz is a senior analyst in the Bureau's policy unit, and she will be presenting the draft consumer guide to you.
Hello. So the Bureau is continuing to move forward with drafting these consumer brochures for the various industries. We began with the alarm and locksmith, and now we're moving to repossession. The consumer guide, as you see, is more geared towards vehicle repossession, but there is a note that this, while it is the most common type of repossession that does occur, that this pertains to any sort of property in which a repossession clause is part of the agreement. We formatted it in a way similar to what was already existed with the alarm and locksmith, and at this time I'd ask for your suggestions, especially repo.
And just as a reminder, the current brochure is almost 8.5 by 11 in size, multiple pages. Sorry, not 8.5, but it's a large brochure. It's not, there's a lot of information, and the committee basically said last time, let's just get down to the salient points. Let's get rid of some of the pictures, and let's just make this more user-friendly, more informational. And this is what we've tried to achieve in the one, basically the 2-page fold-out.
And the Bureau does recognize that this is a difficult brochure to come up with, just because no consumer thinks ahead of time to look at repossession practices as you would if you're doing research to hire a locksmith or an alarm company to install an alarm for you. So it's a little trickier.
Thoughts, comments?
I would make a recommendation that we, this is the first that I'm seeing it today, so as far as the feedback, Chief, we would like a couple weeks to get something together. The things that stood out just glancing at it would be the verbiage conflicts with the vehicle code as well as the current BMP code. So if we could just with Jerry Desmond's office,
So
get
what
back.
language do you see currently that conflicts?
With the licensed repossession agency must display, I'm over on the, sorry, I'm on the far right underneath the vehicle, if everybody can see that in the top paragraph. A licensed repossession agency must display its license number on or the name of its business name, address, phone number on both the left and right side of the tow vehicle. So the vehicle code 27907 says that if you are licensed under the repossessors, you know, if you're currently licensed, then obviously you would be exempt and just have your RA number only. So that was just something that stood out as far as we were concerned, or the name of its business. So the license number would be in lieu of.
Correct. So maybe I can take a look at that, but it is, the section does say display license number, or if you don't want to display your license number, which I think most repo agencies do, you have to display your business name, address, and phone number. So it's either the license number or business name, address, and phone number. So it's one
Yes.
or the other.
It's one or the other. I
Right.
think just from the consumer standpoint, just because it is difficult, you know, is a law enforcement officer going to be handing this to them? I think that just the way that it reads, I think that they're going to interpret it as that has to be, you know, the name and the address, of course, because that's a lot of complaints even our association does receive. Well, the name and the address and the phone number aren't on there. And I think just the way it reads, it's just, I think that the interpretation would be that it does have to have maybe the name and address, and it's already not a, you know, amicable situation in most cases. So we just wanted to look at it, since we haven't had a chance to look at it, maybe get some wording back to you, if that's okay. We would just need, you know, a couple weeks to do that, if you would be.
So this is nearly verbatim statutory language, and any publication has to be very, very narrowly tailored, or it can be construed as an underground regulation. The only way I could see changing this language to avoid underground regulation type issues would be between display and its to add the word either. Would that be something that you'd believe might resolve confusion, at least with this particular section?
Sure.
Okay.
So I'm also wondering too, if we can do the or in both capital letters in bold and underline.
Right.
Just by highlighting it, I think would do it.
Or, so we
Yeah.
can put the either and or, but it is in compliance with the law.
Yes.
So
So
it is accurate in that respect, but we appreciate the feedback that it just may be enhancing that it doesn't need to be both. It's one or the other. And we
Yes,
can kinda-
maintaining the accuracy, obviously, of what, you know, we're not changing that at all. We're not talking about changing like the wording, just the what's in place, the law, but so that the consumer isn't, like I said, a lot of complaints we receive are specifically about this issue, where they believe the first thing they see is that the name, address, and company isn't on the side of the truck. So I think that if it were highlighted, or some of the suggestions here have been very good as far as saying or, you know, like you had suggested, in regards to that, just so they know that you're in compliance either way with that RA number, and they're not thinking that it's mandatory. Because I think the first thing that jumps out at them is that we're, you know, not doing what we're supposed to do. I think that's just from a lot of the social media that's out there, the repossession shows the negative exposure to our industry, and we're obviously, our association tries to let people know that, you know, that's just staged and not people that aren't licensed. We try to let them know that those aren't people that are actually doing this, you know, for a living and aren't licensed and legitimate. So I think if we could just make it a little bit more clear that it can be either or, and they don't have to have both. People think for some reason that even if it says not for hire, they're still thinking that something needs to be on the vehicle itself, the tow vehicle, as far as who the company is and where they're located as well, like the address. Maybe a lot of them do want an address. And that's something we just explained, you know, it's not required that they have it on the truck itself that's towing your vehicle.
I think that adding the IR and highlighting the or.
I'm also thinking
address it.
maybe playing with the format to where it displays and then putting license number and then or, and maybe putting or by itself and then grouping the other three items together.
Like bullet?
Yes.
And is it grammatically correct to have name twice?
No, I saw that and I have marked that out. Thank you.
Eliminate the first one and say, display its license number or business name,
Yes.
comma, address.
That's why it's a draft.
I think the other item we wanted to look at under 7500.1, section S is in Sam and X is in X-ray. The repossession licensee or its agent, I'm right here on the left-hand side, right inside on the top left. The second paragraph, a repossession licensee or its agent cannot enter private property or a locked enclosed area. So the way it currently reads under 7500.1 S and X isn't identical to this verbiage. I couldn't find private property in our act.
Can you tell me exactly where you are again? I'm sorry.
Yes, what you should know if your vehicle is being repossessed, the second bullet point.
Oh, the second bullet point.
Yes, I apologize. I think I said the first. The second bullet point, a repossession licensee or its agent cannot enter private property or a locked enclosed area without the consent of the property owner. But that portion is correct. It would be the second sentence. I just couldn't find under 7500.1 under.
Oh, without the
S as in
consent of the property owner or lessor or renter?
No, the private property portion. I couldn't find that under 7500.1 S or X.
Private property would be anything other than government property. So generally, government property is considered public property unless it's restricted. So I'm not sure what the concern exactly is.
Jerry, would you mind, I don't know if it's appropriate to have Jerry address.
We can do that during the public comment.
Okay.
Absolutely. Unless, do we have to have it separate or can we do it together? If I'm still doing committee comment. Or do we have to wait for committee?
As the chair, that's up to you.
Oh, okay. Well, if it's up to me, then let's go ahead and let's get this addressed right now. So if we do have somebody that can provide some additional information from the public, then I welcome them up here. What's the code section again?
7500.1.
Hi, I guess that's me.
Could you please state
Of
your name
course.
for the record?
Yes, Chief and Advisory Committee members. My name is Jerry Desmond with Desmond and Desmond, and I'm the legislative advocate on behalf of CalR, the California Association of Licensed Repossessors. And we concur with the approach that there has to be real precision in the brochure, and there's a challenge whenever you're trying to take an entire body of law and make it a succinct sentence or two. So we recognize the challenge, and I think that we haven't seen an advanced copy of this and a chance to talk about today until today, and we look forward to working and helping. On the point that's just being discussed today, the bullet point, I think the question is whether, what is the authority of a licensed repossession agency to enter private property? And if you look at 70, I don't have the laws in front of me today, but if you look at it, there is an opportunity sometimes to enter private property if you look at the long-term interpretation of the law in order to repossess a vehicle. If there are some areas where it may be very clear that if it's locked or guarded, you can't get in, but if it's something that is open to the public, but it's private property, there can be occasions where under the law, repossessors will think they have the opportunity to repossess the vehicle, if I have that right.
I think the issue here is that the lack of clarity with regard to, for example, Walmart's public parking area versus a secured and paid parking structure. And that if a repossession company enters Walmart's parking and it's being held open to the public, and Walmart doesn't immediately object to the tow truck being there, they can affect the repossession. Whereas in order to enter the parking structure in downtown Sacramento with the tow truck, they have to go seek permission before they enter the parking structure. I mean, I imagine if they pay the fee, they can enter just the way anybody else does. But your point is well taken in that S is described as private building, meaning any means and includes any dwelling, outbuilding, or other enclosed structure, and X is secured area, meaning and including any fenced or locked area. And I'll have to look at the various definitions again to see how we came to private property. I believe that there's definitely some vagueness here about what constitutes private property, so that we don't accidentally mislead the public that a repossession can't occur at Walmart versus what I believe was intended here, which is they can't, a repossession agent cannot force their way into your garage without either your permission or your landlord's permission. So we'll have to look at that a little bit more succinctly. So your points are well taken.
If I go back to the other bullet point, then I can get out of here. Or
Sure. I do want to just make note that the brochure is on the website. The brochures and the meeting agendas, and it's been public in accordance with Bagley King for the last 10 days. So we've have had it out here. But having said that, totally respect, we're now getting feedback, which is why this isn't a draft form. And that's why we're getting the feedback to see if there's any tweaks. And that's why, particularly as I said in the beginning, we're not taking a vote on this today. We knew that there were substantive changes that were made. It was challenging to try to get what we felt was salient points in there, narrowing it down from the current brochure, which is really, it had a lot of pretty pictures, but it just wasn't as user-friendly or consumer-friendly as we would like it to be. So the feedback that you're giving is part of what, as Alwet talked about earlier this morning, as we develop these type of policy things, the input from the committee is invaluable toward that effort. So thank you. We'll look at it and work together, look at the laws, and see where this needs to land.
And thank you. And on behalf of Keller, that's all we would ask. That sounds very appropriate. And all processes and procedures are above board, and we concur. No problem with the procedures at all. If I go back to the other bullet point and the challenges there, as that Marcel brought up on the what's put on the side of the truck, what has to be posted, I'll just point out, with the same difficulty and challenges of reducing 2 paragraphs into a sentence, acknowledged, but one that might be looked at as the revisions are made is that when it talks about the option of the name of the business, the actual text of 27907 of the Vehicle Code says that it can be the name of the company or the owner or the operator of the tow truck or vehicle. So that's another challenge to address, as a very succinct statement is put on there to provide clarity to the consumer.
So under the Vehicle Code says one thing, but the Business and Professions Code says another. So it's actually illegal for a repo company to operate and advertise itself under a name that isn't registered, and that includes if they've registered a company name. If the business is operating as a sole proprietor under an individual's name and if they don't have a DBA, for example, and they want John Smith on the side of their trucks, that's fine. But if John Smith owns Smith's Trucking, they have to use Smith's Trucking or they're in violation of the Practice Act, regardless of what the Vehicle Code says. So there has to be coordination between the acts. So the Vehicle Code, if they're registered with the name as the name of the business that they're licensed, and that's the licensed business name, it's fine, and that doesn't create a conflict. So we have to read those two in harmony. And so while it looks like reading just the one section, you have to read that together with the registration requirements of the Repo Act itself.
If I can offer up from that great discussion, the word registered comes to mind as something that might be able to be incorporated into here to blend the sections. The way you, Sheila just described it, a possible solution could develop with the use of the word registered name, so then it's clear. But there might be other ideas. I don't mean try to develop it in front of everybody, but there's some good discussion, and the objective is shared.
Certainly.
And I think you hit the nail on the head in many ways where we're having to we're trying to keep this on a one page. That was one thing the committee was really clear on when we brought the brochure before. They liked the brochure format that we put together for the alarm industry and the locksmith industry. One place, one thing. And so the challenge is, how do you distill down the black and white of the law, not deviate from the legislative intent of the law, but get it into something that succinctly explains to the consumer in a manner that can be readily understood from all different I mean, they always say you want to write for a certain, you're not writing, you want to be able to write to them in a manner that everyone can generally pick it up and understand.
Right. A question in terms of the distribution on this. This is on the website, but is this also something that a repossession agency would hand someone that's getting their vehicle repossessed, or is there a availability to have this on a smartphone? I'm just thinking of somebody that's getting their car repossessed and they want to know the facts right away. Is there any, how is the distribution other than this on the website?
Well, first of all, this is, when I said it was on the website, it's part of the meeting minutes, the meeting materials
Right,
for
but I
today.
mean,
It's a draft.
eventually, right.
But the current one is on the website. It's available for consumers under, if you go to the Bureau's website, consumer information. There's no statutory mandate for anybody to hand this out. It's just available. And if we were to, that would require legislation to have to mandate anybody to provide this at the time of the repossession. At this point, as Jennifer started with, this brochure is going to be a little bit more challenging in how do we target, how do we disseminate the information? Because more than not, you're not thinking about when you get the car to repossess it, having it repossessed, right? So we'll do the same thing we did last time with the brochures. We come back to you guys for ideas too, and we have our ideas, but also solicit ideas from the committee on, venues to be able to share this information. But right now, we're looking at just, are we getting close to what, from a policy perspective, this brochure should be like for consumers in general? And I certainly, you can provide additional feedback even after the committee meeting today, and we will take it under consideration and incorporate that into the updated draft that we bring forth to the next committee meeting. And then at that point in time, we can also put it on the agenda, let's discuss distribution ideas.
Okay.
So
Thank you.
you can think about between now and the next meeting.
I was just thinking about Nancy's comment in terms of the smartphone and the application. It seems like this would be something that would be great to have for the consumer, that would be readily available for them as soon as they could possibly get it. As you mentioned, it's not something they're going to research before. It's something that they're going to research at that moment probably, or shortly before that. So any type of access we can give the consumer on a pretty speedy basis would be great. But thank you. Great effort.
I think a suggestion would be, maybe as far as the distribution, I know you said we could put it on the agenda for next time, would be, we would also put this on our website, but also the training that we do with law enforcement, this is something we could provide to them as well. So after the repossession, or when they're called out, or whatever the case may be, they also do like literature from us. We had also provided the books to them before that Laura was referring to, the older style books with all the pictures.
Excellent.
So that's something we would be willing to do.
Okay, thank you.
You're welcome.
Okay. Any other comments from the committee? Great comments, by the way. Thank you. Do I have any comments from the public? Seeing none, then we can move forward to item 9. The discussion of approved calibers for the issuance of BSIS firearm permit. There is a handout in your packet associated with this item number. The handout's also available in the back of the room, and it has been posted on the Bureau's website for those who may be monitoring this through the webcast. And so during the last hearing in April, the committee requested a discussion of the calibers that can be associated with the BSIS firearm permit. And Sam Stodolsky, who's the policy and admin manager with the Bureau, will be providing information on this issue.
Good morning, everybody. Can you hear me? All right, how's that? All right, so does everybody have agenda item 9, the handout that's in your packet? This came up at prior committee hearings, as well as inquiries that we've received from the general public with licensees and permit holders in regards to what calibers have been approved for a firearms permit. If you look through your handout, one of the things we're looking at is, in general, when somebody's issued a firearms permit, it has to specify what caliber they are approved to carry. So going back, you look at what current law, what we have. We have current law prohibits the holder to carry or use a firearm of a caliber not listed on the permit. Also, looking at section 632 of the regulations, it requires the applicant to qualify on the range with the caliber of weapon to be used while on duty as a condition for the issuance of the firearms permit. However, neither current law nor the regulations specify which calibers the Bureau is authorized to approve for the purposes of issuing that firearms permit. So if we look at what law we do have, our course of firearms training is outlined in section 635 of the regulations. It's specific to revolver and semi-automatic nomenclature, and the Bureau does not approve the make or model of the weapon, only the caliber. So historically, the Bureau has approved calibers that have been listed on the California Department of Justice's roster of handguns certified for sale. Now, DOJ is our state authority responsible for regulating firearms. So the Bureau is proposing adopting a policy where the Bureau will only approve calibers listed on DOJ's roster of handguns certified for sale. This would mean that only calibers that show up on that list and are approved by the Department of Justice will be approved for the issuance of our firearms permit. Now, if you look attached to this handout, we printed off what was on DOJ's website on July 1. This gets updated frequently. And if you go on and look at this roster, you can search by make, model, gun type, barrel length, caliber, or expiration date. So by using this, it allows DOJ to decide what calibers can be approved in these capacities. So if you want to scroll through and look at that, if you have any questions, concerns, anything that you'd like to let us know. But at this point, this is the Bureau's policy and how they're approving calibers.
I have a question. I'm just looking at the calibers here. We're looking at 22 long rifles. In the history of BSI's issuing firearm permits, have you guys had actually issued an approved caliber on the permit that says 22 LR or 22 Magnum?
My understanding is the only caliber that gets listed in regards to a 22 is just a basic 22.
Okay. So will the Bureau will actually, if a client comes to a firearm training facility and would like to qualify and carry a 22 as a caliber, the Bureau will actually print it out on their permits as a 22?
It's currently in the system. That's what current caliber that can be listed. And it is a caliber that exists on DOJ's approval.
So Simon, do you have questions regarding that?
On the calibers itself. I mean, we got law enforcement professionals here too that, as a service weapon, as an armed security guard, carrying a 22 long rifle pistol.
But a long rifle's
What's your
not
opinion
approved.
about that?
But a long rifle's not approved because it has to.
No, that's just 22 LRs, the terminology for the 22. That's a terminology of that ammunition.
So.
But again, this goes back to the Bureau does not approve the weapon itself. We approve the caliber to be listed on there.
Right.
So, but when you look at the BSIS firearm permit, it's only going to say 22. It's not going to say LR, right?
Correct.
So by just not including that, and if it's distinctive to that, then it could be argued that that's not permitted because we're only adding.
I think the point he's getting to is not even 22 LR versus 22, but is a 22, he's questioning the appropriateness of a 22 to be carried as a service weapon for an armed any type of officer. I mean, law enforcement officers don't carry 22s on duty.
So this is an issue that has been long-standing with the Bureau. This is an issue that the Bureau's looking into. As you can see, oh, Javier, thank you. Thank you. When did you arrive?
5 minutes ago.
Okay, I'm sorry. I'm deep involved with the agenda. So we can note for the record that Mr. Gonzalez arrived.
Right at 11:25.
Look at there, 11:25. This goes back to the comment that I made in the last meeting that the Bureau, I started with the Bureau in June of 2013. Many business processes have been in place for decades, including what is put on a BSAS firearm permit. We started looking at things, seeing things that need to be improved. You see that already starting to happen with the ad caliber, where we noticed that the current process did not comply with law. And we're refining and doing within the parameters of what can be legally done under current law and regulation. What's being presented here today is what the Bureau can control within the parameters of the current law as it relates to the practice acts that we regulate, as it relates to the section of law that govern the BSIS firearm permit. So the presentation today is responding to the question that was raised during the last meeting of what is approved. This is the current practice. It is aligning with what is existing. The next question is, should it be? And that is what we're starting to work on with regulations. We're continuing to look at rulemaking as it relates to firearms, beginning with one, the use of a simulator. Because when I first came on, I was hearing and we were aware that there were individuals that were qualifying with a BSIS firearm permit solely on the simulator, never having fired a gun with live fire, and they were walking around with a firearm and a BSIS firearm permit. So we are starting to look at all of this from a public safety consumer protection perspective. What's being presented today is what we have authority to do, similar to what we talked about with the adding caliber, what we can do within the current law. What we now need to look at is what should be permissible, what should not. And this will continue to be part of the discussions that we bring forth to the committee as we revise the firearm training manual, and we just look at things overall. If it's going to require legislation changes, then that is something, a different discussion that I bring forth as being part of the administration, the governor's administration. But from a policy perspective, definitely, this is what I would like to hear and the concerns. And these are the discussions that are going to continue to be part of the advisory committee as the Bureau continues to tackle the different things in our business processes where we need to look at it. We need to look at it and what tweaks can be done.
I got one more. If this is going to take place or implemented, can training facilities say no to someone who wants to qualify with a certain caliber? For example, a 50 caliber, 44 Magnum. Okay, so we're protected. Okay.
Yes, and again, we're looking at, this is not just an area that we're going to say, okay, we're just going to use the DOJ list. It's just, we have to provide what it currently can be, what's currently permissible based on what exists out there in the law, but now we need to look at it, as I said, should it continue to be this practice? And I'm hearing resoundingly no. But this is why this policy committee exists, and this is why it's great to have representation from law enforcement as well as people that are involved in the private security industry who also have that law enforcement background. So we're going to be looking at these areas. Any other comments from the public, or from the committee? Do you have any comments from the public regarding item 9? Seeing none, thank you, Sam. It's 11:35. What I would like to do is I can see in the back of the room that our Area Commander Rex Cowart has arrived. And I would like to take up item 7 now before we take a break for lunch. Does that work for everyone? Okay. So item 7 is how the Department of Consumer Affairs Division of Investigation assists the Bureau on unlicensed locksmith cases. As background, the Division of Investigation, which the acronym we use here is DFI, provides centralized law enforcement services for the various boards, bureaus, and programs within the Department of Consumer Affairs. DFI investigators are sworn peace officers, and as Connie raised in her presentation on item 6, the Bureau routinely requests their assistance on BSIS enforcement cases, which are egregious in nature or require the participation of law enforcement in order to be able to investigate it. With us today is Rex Cowart, who's the DFI commander, Northern Area Commander, and Stephanie Whitley, who's the supervising investigator of the DFI's Enforcement Support Unit, to discuss how DFI assists the Bureau specifically on unlicensed locksmith cases.
Morning, committee members. As Laura mentioned, I'm Rex Coward. I'm the Northern Area Commander with the Division of Investigation. And I've been with the division coming up on 23 years and worked up through as an investigator all the way through. With me is Stephanie Whitley.
Good morning. Thank you for letting us speak with you folks. Supervising investigator over the division's enforcement support unit, and I've been with the department. And I'll talk a little bit more about my unit and my role after our commander gives a little overview of the division.
Yeah, I thought it'd be better to kind of give you a little history of the division and where, you know, how we were established and then where we are today. The division was established by Governor Executive Order back in 1961, centralizing investigative services and law enforcement support for all the boards and bureaus under the Department of Consumer Affairs. In '68, they made the investigators sworn peace officers in the state of California, and since then we've continued to provide, you know, centralized investigative services for all our boards and bureaus throughout the Department of Consumer Affairs. Many boards and bureaus, or some boards and bureaus, have some non-sworn personnel that handle investigations at their office levels as well. But if they need any type of law enforcement support, that's what the division is here for. Our structure is basically two large branches in the division, which we call our one portion is our investigation and enforcement unit, which is the original division of investigation. And then we have a health quality investigations unit, which in 2014, the medical board investigators that were reporting under the medical board were moved under the Division of Investigation. They still provide all the investigative support for medical board and a few allied health that they provided before, just the reporting structure changed to be under the division. The Enforcement Support Unit, the original Division of Investigation, we currently consist of about 38 sworn investigator positions. That's in 8 teams that are in 7 different field offices throughout the state. Supervising investigator that's over each office, which consists of approximately 5 investigators and a supervisor for each office. The Health Quality Investigations Unit is about 68 investigators in about 13 different field offices throughout. Similar type of structure. I'll let Stephanie talk on the other supporting units.
So then, besides the 2 operations units, there's 2 kind of support units within our division. One of those is the Enforcement Support Unit, which is my unit, which is meant to be the kind of central point of contact for all of our boards and bureaus and our clients. So what does that mean? That is, I am in my unit, if any board or bureau has any questions about cases, they have something unusual come up, my unit is contacted, and we either decide, number 1, a case is going to be opened, or we do some creative kind of enforcement to help assist that board or bureau without having to rely upon the division. I also intake through my unit all the requests for service, is what we call them at the division. When a board or bureau sends us a case such as an unlicensed case, then it's transmitted to us. It is kind of prepped and packaged in my unit. A lot of background is done before it heads out to the field. And then that Connie was talking about, you know, the criteria for sending the division cases. We're working upon a case acceptance guideline, which was established through CPEI, the Consumer Protection Enforcement Initiative, which really related to the health boards back in 2009. And so it set some criteria on case types that either need to stay with the board or bureau, or that they need to come to the division because of the necessity for law enforcement. So typically in our criteria, we have them categorized in 4 categories: urgent, high, routine. There's another routine, so it's 1, 2, 4. And so really the category 1 and 2, the urgent and high, which Connie was talking about, that unlicensed activity really is in that category 1 case area. So that's something that we accept. The case acceptance criteria really came about because at one point in the division, I was an investigator and we were carrying 100 cases. So you can imagine how productive an investigator is with 100 cases. As there was so much dependence on the division for everything, we would get very kind of swamped us. So that's why this case acceptance criteria was established, was basically say, okay, boards and bureaus who have the staff to be able to handle these lower types of cases, who can do desk investigations, can handle that. The higher priority cases, such as have an immediate threat to the consumer, come over to the division. So that was enabled us to lower our caseload to be way more proactive and timely with. So, in addition to my unit, we have a special operations unit who handles all the internal affairs investigations for the department, for employees, any workplace violence, they also handle too. So in that case acceptance criteria, which I was talking about, the types of cases really the division sworn personnel work on are a lot of narcotics investigations, patient abuse, unlicensed activity cases, fraud, false advertising, which, if you have an unlicensed case and they're advertising, we link that back in there too. Sexual misconduct, theft of ID, so you have somebody trying to impersonate themselves as a licensee, but it's really not them. And again, for BSIS, a lot of unlicensed false advertising, fraud.
As it relates specifically to the Bureau and to the locksmith industry, the division has provided various investigations. The Bureau has developed leads, especially with the advent of the internet and a lot of advertising and a lot of the voice-over phone systems that you can get through the internet versus cell phones. A lot of operations have been developed out of that. At various points, we've worked with the Bureau and set up sting operations for those types of allegations, and then over the years, been somewhat effective with that on a limited basis. It's very specific to a location or a specific county that we've performed those operations. I know that questions have been asked that that it widespread throughout the state, and most likely is if it's through the internet. Some difficulties that we see with those is sometimes those operations, the people that are running the internet programs are not even in the state of California. They out of the country, and these mobile phone, these phones numbers that come up get routed to wherever they out them. That's some of the difficulties that we've seen with those internet type based advertisements. But we have, still continue to try to investigate those. The sting operations give us the person that arrives at the door or at the location, and if they're licensed or not. If they're not licensed, then we'll prosecute them. If they are licensed, we usually gather good intelligence data on that to find out how they're being referred there. Many of them are look like they're just a dispatch service, and they're calling whoever they have on their list to come out, or they may even be operating as a locksmith company and working for them. But until we gather enough evidence to support that, There is going to be some difficulties with probably the Bureau taking, certain actions on those. I've worked with the Bureau and the Bureau staff and talking to them about, possibly contacting, a lot of the internet browser companies, like Google and Facebook and Bing and Microsoft, and maybe as we develop cases that can take action, that they may be able to, companies to remove any advertisements from the internet. But, I don't, we haven't really got to that stage, anytime recently. But we see this also in other industries, under consumer affairs, very similar to the Contractors Licensing Board, Bureau of Automotive Repair. Yeah. So, this Bureau is not alone in that arena of dealing with that, as well as other departments that are seeing fraud being conducted through the
I want to kind of go back to the comment, because this is, this has been an ongoing issue. In fact, when I was going through, it may have been my confirmation hearing, either sunset or confirmation hearing, the issue was raised. What can the Bureau do to deal with unlicensed activity? And primarily in the locksmith, and I think it must have been sunset, was happening just after some recent news reports regarding consumers, calling the 800 number and getting somebody out there who could be licensed as a locksmith employee or not. How did the referral get to? And the challenges that kind of Rex and Stephanie talk about is oftentimes we have this anonymous entity behind the veil of the internet, and we may be able to get the individuals that show up, but we're not able to get to the heart of the issue. And, and as Rex said, sometimes it could be maybe in California, out of state, or even out of the country. How do we drill down on that? And when the question was posed to me, I really can't remember which one it was it sunset or the confirmation hearing? I felt like really, truly, one of the best defenses that we have is an informed consumer, being proactive. Not start educating before they're in that vulnerable position, and calling the 800 number the first thing when they Google locksmiths in Sacramento or locksmiths in Ventura. It's, find out ahead of time. Find out who your local locksmiths are. Check, have somebody there available for when the crisis happens, and don't necessarily rely on what's on the 800 number. I mean, I've even looked at the 800 number and it says local locksmith, and you think you're calling somebody that resides in the area when in fact there's nobody there. Even the stings, I know in the news ads, they kept saying, well, if we can do it as a reporter, why can't the state do it? Well, the problem is the reporters didn't do anything more than what the state was able to do. They were not able to drill down on the internet company that was ultimately involved, whether it was acting as a referral or whatever, able to get the individuals that arrive. So you get kind of a part of it, but you don't really get to the core of it. And I know there was one case several years ago, Rex, that you told me that we were able to shut the individual down, right? But again, if that individual changes to come in another way in the internet through the company, we have no way to patrol the whole World Wide Web. And that's one of the biggest issues that the Bureau is dealing with when we deal with unlicensed activity in the locksmith arena.
Right, because what we feel is we have these unlicensed guys coming into our establishment, and they're showing off that they're licensed locksmiths. And I ask for the license, and they tell me they don't have to show me their license, which is scary. And we don't know what to do with them. We've sent in, do we send in their, they'll hand us a business card, and we can turn it into the Bureau, but I don't know what, but they are all over the desert, and they feel very free there, because I know that you're in Northern California, but we just don't feel like we're getting any protection in the desert.
Well, I think what's important is if you're finding out that information is, and again, it goes back to, making the industry and the consumers aware, is trying to gather as much information on the person that they're dealing with. If they're not willing to show you their ID or their any type of employment license or an identification card or anything like that, is to get a very good description, description of the vehicle that they're driving. maybe
We've
the
taken
lic-
pictures of their
Yeah, the
vehicles.
license
Uh-huh.
plate. That will give us some more information to dig in on that specific individual. And so, that's kind of key, is sometimes we get them and they're very vague, and we don't have a lot to go off of except for, a phone number, and we can start there. But if we can identify those people that the industry is seeing, having contact with, that would be more helpful. And that we can be very, focused and targeted on as a case on that individual. If it expands out from there, it'll just depend on what information we can gain from that.
Andrew, can you describe, you say you're encountering these individuals, in what kind of scenario, situation?
Well, they'll go to a person's home and encounter a lock that they have no idea what to do with it. So they bring it into us to repair it. And sometimes they'll even buy things from us, and they'll brag to us that they're selling it for 3 times what they're buying it from us to these people. And so, again, I've asked them for their license, and they say they don't have to show it to me. And then we sell them everything retail, but then we do take a picture of their vehicle and their license plate and such too. And all we have is their phone number, and that's all we have, along with their vehicle license plate.
So on the sales slip, you can't get the name or anything, like on your invoice thing? Because that kind of information, again, from a business.
Because on their credit card.
Right, start drilling down and getting as much information as Rex just shared, and then.
Because quite often they do pay with a credit card. And so we'll get their name off the credit card, and then we'll get their license plate off their vehicle. And sometimes we'll even ask for, we can give a reference to you. And then we'll get a business card from them. It's the 800 number.
Right, and if we can find out who their client is, their consumer that they're serving, that's always even helpful. I know it's difficult, in the scenario that you gave, but if anybody's picking up that, or hearing from customers that, this person came out and they either ripped them off or they didn't do the service or weren't able to.
Right, exactly.
Might be an
That's another one.
indication, and if they can recall, or if they have an invoice or a receipt from that, then that might be giving us more information to work with.
So what you're saying, just give as much information about them as we can, because we have had clients call and complain about these guys, and all they have is an 800 number.
Right, and
Which
if
is
the clients don't
protect
themselves, it makes it difficult for us to delve into that even further. So having the clients educated is where I see a crucial point.
Which is where I was
for
back
you guys.
during.
Educating the public.
But it sounds like for you, there might be opportunities for you to at least get some information more than what we can oftentimes get from a consumer who's just calling the 800 number. And if you are saying things, I would encourage, submit it as a complaint, and we will look into it. You've now given more information than oftentimes we've been able to glean from the consumer or just off the internet. So I think what's important here is that there are other tools in our arsenal or tool chest here to be able to deal with unlicensed activity. Yes, there's many aspects of the activity is limited in what we can do, but the more information that you can obtain, we pass it on to the DFI and have them
Anticipate doing any stings down in the desert area?
I don't know at this moment. I haven't, seen what we currently have down there. But, we work with the Bureau, many times and on different periodic times, they'll look at the internet and see a lot of activity or a lot of 800 numbers, as they mentioned, that seem to be suspicious. And then, we've worked together and we can set up some sort of operation in that way and see what we can develop. Many times we use their staff to do a lot of the legwork, and then we'll go out and actually catch the people that can come out.
Wonderful.
So Rex has a counterpart, Danny Elias, who's a commander down south, because half of our staff are down south. So we talked about that recently with
Right.
Commander Elias about just what you're asking. So, yeah.
Thank you.
May I speak to you about unlicensed activity referrals that are made through the website? I don't think in 23 years I've ever attended an association meeting where the subject of unlicensed activity didn't come up. It always does. And as private investigators, we're usually pretty good at developing some information that can be passed along through these referrals. I think I've made 2 myself in the last probably 8 or 10 months. The frustration seems to be that we don't ever know if anything is done with that information once we submit that online. It just, we don't know what happens. And in one case I can think of, the guy still running his moonlight business. He's still doing it as of last week, you know. When he's not a sergeant in law enforcement, then he's out being a PI. And so we're dealing with this. And there's a frustration level that gets pretty high when we don't have any idea why nothing's being done. Or is it being done and it's being ignored? So,
Bonnie, would you like to comment on that? Since that's more on the Bureau side than DFI.
I have a question. When you're submitting those complaints, are you submitting them as anonymous under your name, under the association?
no, Connie, you know when I submitted my name's on it.
Okay.
Yeah, I'm not bashful.
No, well, it's just that if it's anonymous, you know, we can't get back to you. We can't let people know
Understood.
how the complaint is going. If it's a complaint where you are the complainant, you should be receiving a letter saying that we've received the complaint. And then the next time you probably would have contact is somebody calling you to get more information. And if those things aren't happening, then you need to contact me. But those are the first steps that you would see. Every complaint that's closed will get a letter saying it's been closed, whether it's closed for disciplinary action or not. Even if it's insufficient evidence, no jurisdiction, you'll still get a letter saying that it's been closed. So, you know, if there's individual cases that you have an issue with, you know, I can research that for you, but that is the normal process.
Okay.
So the only time we have somebody who is a complainant and is doing it under a confidential or anonymous, they're not going to get the information back to them.
Okay.
Thank you, because I did the same thing. I found out where the unlicensed guy lived, his license plate and everything, but I haven't heard back, so.
So we do
It's
have
not
a complaint form on our website for unlicensed activity, and if you want to fill that out and send it in, then it should get to the proper person. If it's not getting to the proper person and you're not hearing anything, then give me a contact.
Well,
Is it
and I
better
also
to
want
use
to,
the
I also
online?
want to talk, make sure where they submitted it, make sure it's the current email account, all that there, and
Yeah.
make sure there's not a disconnect anyway.
And I've the last 2 times I've done it online.
Okay.
Because I thought maybe that was a whole lot more expedient than
Yeah.
snail mail.
I have to look into it. Also, you know, when it is an ongoing investigation, there could be a lot of silence during that period of time because we're
Sure.
doing our background stuff that we have to do. So, you know, you do need to be patient with us, but it sounds like you've been really patient, so we'll see what we can look into those.
Yeah. Thank you, Connie. Yeah. Thanks, folks.
Do we have any other questions or comments from the committee regarding item 7?
Yeah, just a question. In terms of enforcement versus licensed and unlicensed activity, where does the split go in terms of the resources? So do we spend more time on enforcement of licensees, or do we spend more time of enforcement of unlicensed?
Connie, do you want to come up and answer that question? But in general, the cases are allocated not
Connie.
based on unlicensed or unlicensed, it's just, they're allocated.
I'm sorry.
He's asking if resources are more dedicated toward unlicensed activity or other type of.
It really depends on the circumstances as to how we allocate it. I mean, it's just like we've been talking about the priority, you know. If you have a consumer who's being harmed at that moment, or there's going to be a great harm to a lot of the public, we're going to have to take care of those first. But we don't put a back burner really on anything,
Right.
yeah, if it's going to be a problem for, you know, the masses, so.
Yeah, I guess what I'm hearing over here from the industry participants is the unlicensed activity is really the biggest issue, not necessarily the licensed issue. So licensed issue seems like it's more, from your presentation earlier, seems a little less significant than the unlicensed activity on the consumer front.
For the Bureau, when we get unlicensed activity complaints and it's a consumer, we're usually able to handle those within our bureau.
Right, okay.
Those don't usually have to go to the Division of Investigations because we have all of the documentation to support a violation and are able to take the action there. If it's unlicensed activity where we have to do proactive work and go out and do sting operations or sweeps or things like that, that's when we have to send it over to the Division of Investigation. So there may be a little bit of disconnect on those because we only handle certain ones in our office.
Well, and also the resource time for those type of cases are going to be substantially more, but it doesn't mean that any one or less is a priority.
Okay, thank you.
Any other comments? Do I have any comments from the public on this item? Seeing none, thank you very much for taking your time today, coming here today. So it is now noon. So obviously a really good time to take a break for lunch. And why don't we plan on coming back here? It's 12:02. Why don't we plan on coming back here at 1 o'clock? Thank you.
We're okay. Yeah.
Okay, we're going to get back started here. We've got everybody back. Great, on time. Thank you so kindly. So we are now on item 10, which is the proposed updates to the Bureau's Firearms Manual. There are handouts in your package, which include both the suggested revisions from Bureau staff as well as the actual firearm manual itself. And as noted in my Bureau Chief update during the April 7th meeting, with Sunset and Breeze transition behind us, the Bureau is now focusing on improving our operations. And this next item that we're about to discuss reflects just one of these efforts. With the exception of a couple of minor revisions, the current BSIS firearm manual has not been updated since its inception, which I think is about 20 years ago or so. And so there are areas definitely in need of change, reflecting current law as well as other things that need to be looked at. Sam Stadolsky, Policy and Admin Manager, will be presenting several items in the manual which the Bureau believes are in need of revision. And so this is going to be the beginning of the discussions from you and just the beginning of the discussions of where this manual, if it's landing where it needs to be or what type of changes are required.
All right, so everybody should have the handout in front of them for agenda item 10, as well as a current copy of the Firearms Training Manual dated October 2012. So if you go through the handout sheet, we'll kind of give you an idea of the areas that we want to focus on. For starters, item number 1, the firearms training outline will need to be updated and revised. Item 2, we want to go through and make some changes to...
Can we take a little bit of time to go through it? So when we're looking at items 8 through 13.
Or pages 8 through 13.
So pages 8 through 13 reflect the changes that are going to be part of item 1. And so what are the things that we're looking at?
We're looking at, as previously discussed with our firearms regulations that are going through the process right now, that rulemaking package makes changes to this outline. So this outline that's in the manual itself will have to be changed because this outline currently exists in regulation, okay? And that will take you from page 8 to 13. And a lot of the changes in that outline are are somewhat minor. They're mostly technical changes. It's doing some cleanup of the language. We are changing on page 12 under Section 6, range preparation, the targets that are specified in there, those will be taken out because we have regulations that will further define what those targets are going to be. We're going to set the minimum standards for those targets instead of prescribing a specific target to be used.
Sam?
Yeah.
Sorry. On page 13, under range training, may I suggest under the A instructions, drawing, holstering practice, dry firing, and loading procedure, is there any way you guys can look into adding a malfunction clearing during range training? Because currently, right now, in a course of fire, if a shooter has a malfunction, they have to raise their hand and wait for an instructor to give them the commands to clear it. Why can't we add it during the course of fire? That way, it doesn't become a habit for a shooter to go, oh yeah, I got a malfunction, hold on. And is that something that you guys can look at?
Absolutely, and this is really why we're presenting this to you. We would like your feedback. We would like any input that you guys might have as we go through making these edits.
Thank you, sir.
So, Simon, reflecting off of that, do you see any changes in the previous sections that would need to build on that? Anything through the
Yep.
fundamentals or under item 4, Roman numeral 4, or even range preparation 6 that might be relevant to the malfunction issues?
I mean, he discussed about the equivalent of the NRA B-27, the targets and all that stuff. That was one thing. And probably later on, as we go down to the case studies,
That's what we
is the
want.
perception of threats. You know, if there's a weapon involved, you're outnumbered, that kind of stuff. Just kind of like to update that. Other than that, everything else pretty much looks good over here as far
Okay,
as.
so I was just curious if the suggestion that you made for Roman numeral 7, to add another subsection there for malfunction cleaning, if that, and you saw anything impacting anything else in the outline previously, and it sounds like no. So, okay, thank you.
So I would like to just point out that the pages that we're discussing, 8 through 13, have been adopted separately in regulation. I think some of you are aware of that. Not everybody may be aware of that with regard to the training requirement for firearms. So while they appear here, changes to this outline go through a separate regulatory process. So it's important that we hear the feedback, but it's like a two-part process for this particular document. We can't change it in one place without reflecting it in the other to make it legal.
The course outline or the manual? Just the course outline.
This is for the course, if we're going to
Right.
make changes to the course outline,
Yes,
in order for them to be
absolutely. Understood.
enforceable, we have to
Right.
go through the regulatory
Right.
process with those.
Right, understood.
And with that said, I mean, the manual itself fills in the gap on a lot of, we have the outline and regulation. The manual helps serve to fill in all the little areas within that outline. So while it may not be something that has to be in the outline, it's something that could be addressed later on, I would think. Item number 2, we have on here making non-substantive changes throughout the manual to provide better clarification. There are a lot of sentences, the way it's written or the way something is explained that, has even caused confusion for us, and we're trying to figure out what the intent was at the time it was written, how it's being interpreted out there in the field by the facilities and by the students. So we want to go through and just try to better clarify some of those items that are in there. Number 3, there's a lot of references in here to the Business and Professions Code, Government Code, Penal Code. We want to go through and basically replace them so that we have current law in here. This has been updated since 2012, and I can guarantee you a lot of these sections have changed in the past 4 years. So we want to make sure that we have the most current law reflected in the manual. Item number 4, we want to look at, and this will be on pages 16 to 17 in the manual, we want to update the information as it pertains to firearm prohibitions. And again, this is something we would be updating it based on what Department of Justice is doing, what they consider a firearm prohibit and how they enforce the laws. Have something to add, or?
Just a suggestion on page 17, under qualification and permit to carry a firearm by caliber, maybe this would be a good area to give the information regarding additional calibers.
Right.
And again, echoing what was just shared, we're going to have to look whether it's something we can just do in the manual or we're going to have to do through the rulemaking process. Either way, we'll still be moving forward, but one is not as instantaneous. It's just us making edits to a manual. It's going through the whole administrative process of changing regulations, the Bureau's regs.
And that is number 5 on the list. is adding clarifying language to the best of our ability for the approval of calibers. Number 6, we want to update the information as it pertains to peace officers. With different law changes, some of the information in here needs to be changed to reflect what current law is. Moving on from there, item number 7, updating proof of citizenship list. We want to look at the list that is listed in here. We want to make sure that that is up to par with what current law states are acceptable forms of citizenship.
So, out of curiosity, when times that I've looked at firearm permits, most often is the passport or birth certificate. Do you see much use of these other documents?
I did come across with a Native American tribal document, which is an ID, but I know that it's not BIA approved or it's not recognized by BIA as an actual tribe. I basically said, you got to give me a birth certificate or passport. So that's probably something that needs to be clarified here, that it has to be an official tribe under the Bureau of Indian Affairs.
Matt, anything that you see when you're working with your facilities?
The most popular, of course, is the birth certificate and then the U.S. passport, and then we do have several people that bring in the permanent resident card.
Do you see any documents that you, exactly what you just talked about with the tribal document, but are there any other documents that you see that are problematic for you that you're not sure about, or?
No, that's about it so far. Most of the time they bring, when I give them, bring a copy of your U.S. passport, it has to be valid, birth certificate, or if it's a U.S. territory, Puerto Rico, they're pretty good with that.
Do you echo that, Matt?
Yes.
Right, item number 8. One of the things that we found that we receive a lot of inquiries on has to do with concealed carry and the transportation of firearms. So we want to look at this section and make sure that we are providing enough information in there and that information is clear. It appears that there may be some confusion out there now, so we want to go through and make sure we clarify that to the best of our ability.
May I say something about maybe to clarify when on the text it says you must satisfy one of the following 3 requirements, and when you put concealed weapons permit, might want to put a California concealed weapon permit, because you guys have a lot of people from out of state, like Arizona and Utah. And
Where are you, Simon?
I'm on page 26 on the first paragraph,
Got it.
line 4.
Thank
Anything
you.
else on that? Okay. Item number 9, we wanted to look at, if you skip ahead to page 47. We wanted to go through and update the information that's provided as it pertains to the avoidance of deadly force and the de-escalation of force. Simon, you had mentioned some of the scenarios and stuff that are in there. We would want to look at how effective those are and whether or not they could be revised, or if they need to be reworked, or what we could do to make those situations better, as well as the relevant statutes involved as well. Item number 10, we wanted to add language as it pertains to the approved targets, and this is something that will come down once our rulemaking package is complete.
I'm sorry, I actually got something from, can we step back a little bit? On page 47, under number 3, Title 16 CCR, on the first paragraph, letter A, B. On the last sentence, that's basically saying an applicant should complete and pass range qualification course of fire requirements by firing 50 rounds for score on 2 separate occasions, but no sooner than 4 months apart within each year prior to the card's expiration. Can we make it like within 12 months?
If you notice on the new firearm application form, it is reflecting the 12-month period, and that was something that, it's a really good observation, because it can be so subjective when we just say. And so.
Will it appear on the new firearm training manual, though?
Yes.
Okay.
Yeah, right. So-
Every
so-
reference to law that's in here will be updated.
And those, and you're hitting the nail exactly on the head. This is exactly what we want to do, is we want to provide clarification to those gray areas where people are like, well, what does it exactly mean each year prior to the expiration? Well, it's not necessarily the calendar year. If you get your permit in December, right, of 1 year, it's basically the 12, so the firearm permit is good for a 24-month period. And so within that cycle of the 2-year term, it's going to be a 12-month period each time. That's why the specific language was changed on the application for the firearm permit, both initial and renewal, to reflect that 12-month cycle. And these are the type of things that we are now going to bring into the manual.
Thank you.
Okay, so item 10, adding language on approved targets. Again, this is something that as we move forward with our rulemaking package, we will include additional information in here so that that's more clear. And then last item on the list, starting at page 91. We want to update the information on involving peace officers, especially as it pertains to... Section has a lot of kind of frequently asked questions, and we want to revise these to reflect the current questions that we are actually getting, and as well as updating the information as it pertains to different changes in law that have come down in recent years.
So at this point, we're starting the process, correct? We're going to start, we've got this in a soft copy, and we're going to start making suggested edits. How the committee can provide certainly input. You're going to be, this brochure, the manual is also available on the Bureau's website. And so if individuals have suggestions, they can submit those suggestions through the BSIS general email account, which is bsis@dca.ca.gov. And if you don't remember that, just go to the Bureau's website, and in the very top right-hand corner where it says Contact Us, click on that icon, and it will get you to the general email account. And certainly we will be looking for any suggestions, further suggestions or feedback regarding the revisions. We anticipate this being a very laborious process. I don't believe we will have an updated version for you for the next hearing, but potentially maybe the second hearing if we're doing this quarterly, so about 6 months from now.
Due to the nature of the revisions and the likely requirement that some will require some kind of task force involvement, especially with the vignettes that are in here for de-escalation and et cetera, that's going to require the advice and counsel of industry experts in order to get the current information. Some of this information is 20 plus years old. Policing standards, expectations of security guard standards, those have modernized. And so it may be necessary to request
Additional
experts to come in and give advice as to how that should be handled. Updating the laws, updating references to the laws, that's going to be the easy part. Some of the more in-depth stuff is going to be the difficult part. So we may break it down into sections and update those as we go to bring the parts of the document that we've made revisions to back to you. I've been working with Sam for a good bit on this. This is a long-term project. So the vignettes are going to be the hard part. Some of the other stuff is going to be relatively straightforward. So yeah, within 6 months we'll have a good idea of
framework.
A framework of how it's going to look and where we're going from here, and how much work on the vignettes and the rest of that portion of it is going to be required. And any holes that we currently have. And if you know of holes, if you out there working in the industry are observing holes in this area, the sooner we hear about what you think the big holes are, the easier it will be to try and fix the guide going forward.
Is that another no?
No, it's not another no.
No, I'm just kidding.
There will be documents in
No.
6 months.
So no, and I guess that's what I said. You don't anticipate any additional updates at the next meeting. We may have some updates available for the subsequent one.
Chief? Like the guard card manual, I can talk about suggested revisions on this for hours on hours and can't do it on the fly right here. Is there a possibility of some sort of a work group that would be put together to assist with suggested changes for this manual?
Absolutely. And is the inquiry similar to the work group that we formed for the law enforcement fact sheet, that it would be members of the committee? Is that what you're asking?
Yes.
That is definitely a possibility. It's not something we can do today because I don't have it agendized, but perhaps for the next meeting we can, since we'll be moving along, to put that forth.
Got one more. I was looking at the list here of the things that you guys are looking into changing and updating. I was curious that how come or if you guys maybe are looking into updating the course of fire itself too?
You mean the firing schedule and stuff like that?
Correct.
We haven't looked into that part yet.
Okay.
But again, I mean, that's something with feedback from the industry. If there's a need there, then we can move forward with that.
So out of curiosity, do you have thoughts?
I think I'll just email it.
Okay. Okay. Fair enough. Fair enough. Javier, I saw that you had a question.
Yes, Member Lujan's, just to follow up on his comment about a work group, would you mentioned only opened up, would it only be opened up to members of this group? Because I think if, as council has indicated, that there's going to be some more technical assistance needed, I think we need to be open-minded to, if we're going to need somebody from post, the peace officer standards training, someone from there, just be open-minded that we may need.
No, absolutely. And in fact, you bring forth a good point, because the original manual did include individuals from law enforcement, individuals from post in its development. And so, yes, we do see some collaboration in that. Keep in mind that anything that goes through the rulemaking process is open up to all parties for input as well. So it's not anything that's going to be developed just by the Bureau alone and solely alone. It is going to be a collaborative process, before final review, at different stages. As our council has advised us, this is going to be quite an undertaking, and more than likely it will be done in steps. And based on those steps, it will be when we'll bring individuals in. That's what I'm envisioning.
Thank you so much.
Questions from this side? Do I have any comments from the public regarding this agenda item? Seeing none, let's go ahead and proceed to item 11. Proposed revisions to the BSIS law enforcement fact sheet by the committee work group. So and there is a handout on this, was in your packets. There's a handout in the back, and it's part of the meeting materials that are posted on the Bureau's website. And so during the April 7th committee meeting, a motion was made and adopted to establish a work group consisting of Lynn Moorfeld, then committee member Thomas Uretsky, to review and provide input on the Bureau's draft law enforcement brochure or fact sheet. And just as background for the new members of the committee, we were asked to put something together to assist law enforcement when they're out there in the community and coming across individuals. This fact sheet is focusing on security guards and proprietary security officers, and the distinction between the two and the way the BMP code governs them. So it was an effort to develop a one-page document. The Bureau presented a draft document, and then the work group was formed in order to provide feedback and refinement. I guess I would like to start with you, Mr. Moorfield, as a member of the committee, if you'd like to share anything on the work group's efforts, and if you have any comments. The fact sheet, is it seen today? Does it reflect the input and the efforts undertaken?
Thank you, Chief. First of all, we had a great foundation from staff in terms of where we were going with this and working with Carl on this particular issue. Really, we didn't do too terribly much other than some wordsmithing. And then the big thing that we did on this was is we flipped the tone of it. So we kind of made it, hey, this thing must have, you can't have, you must have. And then we put quick facts at the top, and then know the difference, and then the citation authority at the bottom. So we really wanted to make sure that with 6 bullet points that law enforcement had pretty much the most of what they needed. And then they could drill down from there. So that's what we started. The comments, a couple of comments that we had was about off-duty police officers or retired police officers and what their duties were for the fact sheet in terms of concealed carry or carrying a firearm, or what they had to do specifically for it. So that was the only thing that we couldn't figure out how to put in here. But I think we kind of came up with a pretty good idea of what this should be, and just a quick reference sheet for law enforcement. So thanks to Carl for his efforts on this, and Thomas Uretsky as well.
Thank you for that update. So recognizing that all the information is now in a document that is being seen as relevant to somebody out, particularly local law enforcement, that may be encountering situations where they have questions, I guess the next question I would ask is, you're not going to want to carry on a one-page document. So from a law enforcement perspective, and I know I have other members over here in that arena as well, it would require putting the text in a very small format, an accordion pocket. I mean, what do you guys envision as being something that would be easily accessible for somebody who's out there in the field?
I believe you guys had an ID card size type of.
With a lot of little pages.
Right.
And you believe that's the same format that should continue?
Yeah, I carried that for a while, just as a reference, but, I think that would be good.
Captain English, do you have any comments?
No, I agree. We have similar things where we'll take that and we'll just assign it to a car, not to a person. So, because the cars are over and over each day, given to different shifts, so it's with the car all the time. So it helps not having to make 1,200 things to give out to the deputies, and you just assign them to the car, and they keep it in the back or for a reference.
So when it's signed to the car, it still would be that smaller little pamphlet as opposed to something, it's not a binder that's kept in the car.
No, it's just the deputies put things together and keep them in the car for reference. A lot of our stuff now is all the computers in the car, so it's all online. But I think the easiest way is to have them on a ring or some type of a little thing they can carry as they're walking out and making contact with these people at the different areas of patrol.
I think what you mentioned with the computers in the cars, a lot of agencies have an internal intranet site where they have a lot of reference material stored, and so once this is pushed out to different agencies, they'll likely put that, make that available there so that officers know they can go to this reference site on their internal system and look for that information.
So would you see something scanned like this in addition to a pocket, or the pocket that we put in a PDF and then share it? What would be the most?
I would think if you pushed it out electronically to law enforcement agencies and said hard copies are available at your request, that way you're not sending them out that are going to go sit in a corner somewhere. That would the agencies that have the ability to use an electronic version would do so.
In this format, or more of the small pocket style?
But it's going to come down to, if you want to put it, we call it SharePoint, but it's the same thing. We have our own access to the computers to either give it to everyone in the department or just certain cities or certain divisions of patrol. That would be the easiest, but you'd have to go give some type of give this to the sheriff and have him give the okay, because he's the only one that okay that. Whereas when you do it as the pocket thing, it can be presented to the different cities and the agencies within those cities to decide if they need it, because especially in Ventura County, we're dealing with county area, beach area, and cities, and in some of our little communities, unincorporated, it wouldn't even come into effect because there's nothing but agriculture or houses. So the easiest way would be to get this to the heads of law enforcement agencies to see if they'd want it and would be willing to put it on their computer-based. Because we do everything out of the cars. Now it's even they have cell phones where they everything, run people, whatever we need to do in the field, we can do it on a cell phone. Send pictures to each other, whatever we need to do.
So, working through the associations then, is what I think I'm hearing, the Sheriff's
Right.
Association, Police Chiefs Associations, and getting it out through them, and then seeing if we can get it.
Thing
They
we want
push
to
it out.
provide, and then they will get it, and it'll go up, and then the sheriff will look at it, or the top person of that agency, and give it a blessing, and away we go.
In soft copy, this format, and then the pocket card, if it'd be available in hard copy.
I have a
So,
question then.
I'm sorry.
I'm sorry, I have a question. Would that be the same thing as these other brochures we've been talking about, like the alarm companies or locksmith stuff? Would they have any of that information on board for the police?
There's different agencies and groups that come together all the time wanting to take various informations and bring it together. It just depends on, are we talking about businesses, or are we talking about laws? And that's what, I mean, because every city has their own regulations and their own city ordinances, and it changes. I mean, there's some rules that apply to specific cities. So if it's a law thing coming down, then your best bet is to go through the head of the agency, because it affects everybody. But there's different, noise complaints. It could be 9 o'clock in Ventura, it could be 10 o'clock in Thousand Oaks, and it could be 9:30 in See Me. So you can't put that out. It has to be more specific. But anything that is a one-way direction that everyone needs to abide by, the best is to go through the sheriff and put it out through our SharePoint, which everybody with an email address on our department has access to it.
And I think you're raising some good points, is can we give the brochures in the same push out with these? And I would say we can approach the issue with the associations and see, because there is relevant information there as it relates to the alarm. Well, also, once we get the repossession one, all of those brochures provide relevant information to what's going on if it's touching law enforcement. So yes, I think it's a good point, and I think it's worth the Bureau exploring as we reach out in regards to this specific fact sheet. This one in particular, we get a lot of calls from local law enforcement that don't particularly understand the nuances of the acts between, all they see is private security. But is that private security individual governed by the provisions of the Private Security Services Act, quote unquote, as a security guard, or is that individual governed as a proprietary officer under the Proprietary Private Security Services Act? So that was the point of this. Who can work armed, who cannot work armed, all of that. So, but definitely those other brochures provide relevant information as well. So, I guess at this point then, I believe, again, the committee serves as policy, it provides recommendations to the Bureau. It's not policy development, but similar to what we did with the consumer brochures, I would like to say that this is finalized in content, and so we're just going to be looking at the best method for rolling it out, or formatting for rolling it out. So I would like to make if I could get a motion from the committee that this document is final, no further revisions are needed in regard to as of today. Oh, I'm sorry. Hold on. I do that after the motion. Hold on. So thank you. So, do I have a motion from the committee?
I move that we adopt the Bureau of Security and Investigative Services fact sheet as presented to us today.
Do I have any comments from the committee regarding the motion? Do I have any comments from the public regarding the motion? Please come on up. State your name for the record.
Ryan Bear. I'm the qualified manager for Smart Guard. What I was going to suggest is the distribution governs reference for law enforcement. They're put out in an electronic but searchable format. Probably be the best resource for the officers in the field, as well as not just going to the officers. Once the chiefs approve them, they should go to the district.
So what we would like to do is then explore that, because obviously that makes the functionality of the document, it enhances its functionality to be able to readily go into it. It's certainly worthy of exploring. Thank you.
Officers in the field, when they're looking at it and they don't know what's defined here, who can carry this weapon, can this fellow actually carry it concealed or not, if he can search it.
Thank you for your input.
Good afternoon, committee. Al Howenstein, G. Albert Howenstein Jr., a retired police officer, a retired elected county sheriff, and a former director of the former Office of Criminal Justice Planning, and having dealt with a number of these things. Just a couple of observations. One, I think it would be very advisable if you all would talk with POST, Commission on Peace Officer Standard and Training, and have this information become part of the standard training for all police officers in the state, so that they would have an understanding of really what the role is and the difference between private security and the various levels, and have it right from the beginning when they first go into the profession. I think that would be really very valuable. And for those who are, I'm sorry.
So are you saying that you believe that this document should be incorporated into the basic academies as part of the training, just so they understand?
Probably an expansion of this document that is a little more expansive, much similar to what you have in your firearm training manual, as it explains the difference in the roles and responsibilities, all of those kinds of things. I think that there is a very dearth of knowledge in relation to truly what private security are and what they should be doing and what they can't do, as well as then some confusion that may have evolved with the development of the proprietary security officer. And I think the sooner that we train our law enforcement professionals on the whole knowledge of the whole realm, the better off everybody's going to be.
Okay. Well, thank you for your input, and it will be
And one other comment, and it's just one of those things. I noticed that there's a lacking in the form of BSIS approved patches and badge, not just a patch or a badge. And I don't know if you want to have that distinction clarification, but I think that's very, very critical. And just following up on what Mr. Bear said, a phone app would be extremely valuable with, how quickly we can today hit our smartphone and find any information that we want to have, would certainly make, I think, life much easier for our law enforcement professionals. So I thank you for your time and appreciate it. Thank you.
Thank you so much. Appreciate your input. So there was a very, I'm so sorry. Please state your name for the record.
Good afternoon. My name is Robert C. Smith. I'm the CEO and president of Nightclub Security Consultants. I'm a licensed curriculum provider for the PSO. I would have loved to have been a part of the work committee, at least the discussion point. The first bullet point there, guard card. Since 1973, security guards have been carrying their guard card. Every cop has walked up to a guard or heard about the guard card. Guard card is the slang term for security guard card, the registration card. By calling PSOs guard cards and security guard registration cards guard cards, I think it opens up some confusion for the officers who are still out there in the field, inadvertently asking a PSE for their guard card, their guards with guard cards. They'll bring out a PSO card and they'll say, oh, you got the new PSO. That's what I meant. So if we just leave this term as guard card, which encompasses both, I think that's a mistake. We've got a separate license for a separate type of guard, and we should keep the two distinct, SG or PSO, instead of lumping them in as guard card. I think that's, this is a new addition from the last one. I didn't see that, and I think that's an important point. In the city of San Diego, I was a police officer for 20 years, retired 4 years ago now. They changed the language of the entertainment permit purposely to make a unique distinction between security guard and PSO, because they wanted their they wanted their officers and vice detectives to know the difference. And here we're going back to calling them all guard cards.
No, that's a really good point.
That's one suggestion, especially based on the history. You start off with PPO and then PSC, and I got that. I think a better place for the enforcement side of this, the enforcement points, would right underneath each one. So underneath the PPO, and you have the definition, right under that, just put enforcement with their appropriate sections. Same thing for PSC, same thing for security guard, same thing for PSO.
And I believe the last time we got feedback to put that down below.
No, the last time, the only thing I said, maybe someone
Oh,
else
not
gave
from you.
feedback.
I'm not saying not from you.
The point I made, I'm going to bring that up now, is under unlicensed activity citation authority, you only have listed 2 different positions when there are 4. There's unlicensed security guards and unlicensed PSEs. Those aren't listed here anywhere. You've got the PPO and the PSO.
Right, the proprietary security officer. I think PSC is a proprietary employer, but we're only addressing the proprietary officer. So we're addressing both the security guard and the proprietary security officer, and those are the citations of authority for each.
Then why are we listing PPOs? See, we've got know the difference from a private patrol operator and an employer, a private security employer, and then we got security guard and PSO.
Got it.
And I think it's good for the officer in the field to know all 4 different sections and all 4 different functions of what they are.
Okay.
Under PPO, the citation authority, you've got listed the 16240. You've got that now under the PSO, and that's also true for the other 2 positions. Working in any unlicensed position is a violation of BNP 16240. So that would encompass all 4 of those, along with any lesser offense, such as what's listed under PSO, the infraction, or I don't know if it's a misdemeanor, I'd have to read it, but I think it's an infraction section under 7574.32C. I just think having them, each of them, for each individual one, the officer now has some discretion to say, all right, I'm going to write you that smaller violation, knowing they have the bigger hammer in their back pocket should they need it with 16240, a full misdemeanor state section with a maximum fine of $5,000.
So I'm actually thinking that part of the revisions that were made to this document, I thought we had more on the first one. And I don't have a copy of the first one with me. Does anybody have a copy of the original one that we presented to the committee? Because then I know that the recommendation was that it needed to be consolidated into one document, and then the focus was just going to be on the guard and the proprietary officer. But I see what you're saying when we get down to the unlicensed citation activity, that it's going back to, it's mixing apples and oranges with PPO and PSO. So I guess then we're going to have to go back, since now we're looking not at this one-page document and we're looking at one more comprehensive.
See, and that's the other part of this. As a patrol officer, I carried around my ticket book. I had my cell phone. I could go to my car from my dispatch system and use the system and send things on my cell phone. But when I needed to research a document, or I needed to research a section on unlicensed cab drivers, unlicensed locksmith people, it was too difficult to find that in the computer system. So I went back to the cheat sheet that I got, and it was a tri-fold, and it fit right in my ticket book. And I always had it tucked in the back of my pants, my whole ticket book, and I always had the tri-fold. This would be an easy tri-fold for law enforcement as a flyer, much like the ones that were previously discussed. With all the, and it would give the working committee more room to put those points on there about the concealed law enforcement, retired law enforcement.
Okay, so, I do believe you're raising some valid points, and so I'm going to have to ask for legally, since we do have a motion, do we take a vote? Do I have to finish, since the motion has been posed?
I would like to withdraw my motion.
Okay. And that's exactly, I was asking if we had to have a vote, or we can withdraw the motion.
And if I may add that, I mean, withdrawing the motion, I'd like to suggest that we take into consideration the comments from the public and come back for our next meeting with the revisions.
Okay, thank you. I believe that would be a judicious way to approach this issue. So I just want to make sure that we are capturing the thoughts that we put forth. I totally agree with the Bureau-approved patch. Definitely, that needs to be noted. In regards to breaking this down even further, I think what I'm hearing is we need to break it down to the violations and the distinctions that are associated not only with the guard, the PPSO, make that distinction clear, but also to their employers, the PPO and the PSC, and then the authorities that can be used to cite.
Yes, ma'am.
Okay.
I think that would help the newest officer that wants to go hard charge and look for someone who's unlicensed at a bad bar or a bad hotel or a bad individual operator. They know exactly what to look for.
So honestly, when I'm looking at this document, it sounds like a lot of changes, but I think it's really going to just be a little bit of tweaks here and there to
It
get
is,
it
ma'am,
where it
and
needs
if, and
to
if
be.
if it's allowable, I'll make the changes on a simple document. I'll just send them to the committee chair, and they can do what they want with it. Like it, change it.
You can send it, definitely.
Okay.
There's nothing that prohibits you or restricts you from sending it. We'll look at it in its entirety. So
Thank you.
I appreciate the public's comment. These are very, very good suggestions. So, kind of want to double back. I know we withdrew the motion. Is there any other comment from the committee based on the public comment that was heard? No further public comment? Seeing none, let's go ahead and proceed then to item 12, potential revisions to the private investigator pocket card. So, since I began with the Bureau in June of 2013, I have received various comments regarding the identification cards that are issued to private investigator licensees. This item that we're bringing forth is another example of the Bureau's efforts for operational improvements now that Sunset Review and Breeze processes are behind us. The Bureau recently solicited feedback from private investigators via a survey it developed and posted on the internet to identify key concerns that licensees may have regarding the identification card. With us today is Carl Bierman, who is a senior analyst in the Policy and Admin Unit, who will provide a brief overview of what the survey results revealed.
Okay. How's it going?
Chief,
So like
I have
Laura
a
said,
question.
the last
Was there,
committee hearing-
sorry, was there any documents or on our packet?
No.
Okay, just to make sure. Thank you.
Yeah, this is just going to be some statistics and results from the survey. So we created a survey. We sent it out through the various industry associations. We had a lot of people respond. These are essentially the results. 86% of all respondents said that they wanted to revise the pocket card, which is a lot. So that's good. We also asked some questions as to what they would like added and changed, and then there was a spot for them to write in. And I can go over those results a little bit more too. By far, the number one thing was that they wanted it to look more professional. And they suggested things like a more prominent state seal, maybe having a signature line, that kind of stuff. Some even went so far as to suggest that they wanted it to be a government-issued ID, like a driver's license, which is a bit of a stretch, I think. Things with holographic images, things like that. Several people also said that they wanted an expiration date put on it, because currently there is no expiration date. And 53% of all respondents indicated they'd be willing to pay more than $25 for a revised pocket card with these additional features. 'Cause currently the fee is $6, $16, I forget. Anyway, so they wanted a lot of different things. The number two suggestion that we got was a photograph. The thing that's a little weird is that the pocket card already has a photograph, and that brought it to our attention that there's a lot of confusion between the actual private investigator license and the private investigator pocket card. Most of the recommendations almost seemed like they wanted to merge the two into one ID. that would also be equivalent to your license. One of the things that we asked was if an expiration date was added to the pocket card, would they be willing to pay this higher fee for the ID every renewal cycle? And that was split. Pretty much 60 said yes, 40% said no. But a majority was still willing to pay the increased fee. Some commented on the quality of the photo on the pocket card. Some commented on the color of the pocket card. We had all kinds of different responses. One suggestion was, since many PIs also have a firearms permit, that we add the firearms permit information to the pocket card as well. But that would only be possible if an expiration date was also added to the pocket card, because you can't have a firearm permit that doesn't expire. Some respondents went so far as to say that they wanted the last four of the social on the card. Some said they wanted chip technology on the card. Some said they wanted all kinds of stuff on the card, and due to confidentiality and just identity theft safety in general, I would not recommend that we add those types of personal features on the pocket card. Overall, I think we got a lot of good feedback. Some was a little out there, some was good, but we're definitely going to have to look into making it clear what the difference between the license and the pocket card is. And if there is to be changes and adding expiration to the pocket card and it taking the place of the license, we would need some sort of legislation put through to make that legal. Do you have anything to add, Laura?
Well, so is that the conclusion of your presentation?
Yeah. I mean, that's all the results from the survey.
Thank you, Carl. Before turning it over to the committee, I do kind of want to bring to light a few things that I noted from the survey results. There were numerous comments about not liking the dark color and the desire to have the state seal to be larger and more prominent. And based on that, that is telling me that many PIs are still using the older card, perhaps even the one that they were originally issued. Because, again, as I stated, this was almost one of the very first things that came before me was when I first started with the Bureau in 2013 was unhappiness with the card and a typographical error in the card I think the department's name, in fact. And so in June of 2014, we did revise the pocket cards within the parameters of the existing contract that exists with our current vendor for issuing the exam and issuing the pocket cards. And in that 2014 revision of the pocket cards, they're now white background with the state seal and the BSIS logo very prominent on the document. So some of the first things that I guess I would want to share with the industry is that if those concerns are with the darker color and less prominent, they need to see about getting the new card, because there's nothing that prevents them from going in and getting a new pocket card. It's not a license, it's a pocket identification card. And so long as they have clear, valid license and identification when they go to the PSI, there should be no, and payment for the new pocket card, they should be able to get that. Additionally, and I'm going to echo what Carl shared, there definitely, it was something that I had suspected in just the conversations I had had with individuals that wanted to have the pocket card updated, that there's confusion between the pocket license and the pocket photo identification card. And again, the license is driven by having a current license, and a new pocket license is issued to the licensee for each renewal cycle. The identification card is static. It does not change unless somebody's like, they've had it for 20 years and, like for me, my hair is not necessarily dark anymore except for some cosmetic reasons that you want to go and have it updated. But there's nothing that changes on the pocket ID card once it's issued. So I think we need to get out there a little bit more on the clarity between the pocket license card and the pocket ID card. Business Profession Code Section 7528 governs the pocket license and 7529 governs the pocket card. If the desire from the industry is to have features of the license, such as the expiration date, or incorporated into the pocket card, as well as additional enhancements, then looking at Section 7529, there will likely need to be legislative needs, or legislative changes to address some of those desired changes. But in the interim, the most prominent ones with the color, the more prominent seal, that is currently available. So I'd like to continue working with the industry to see if there is a continued interest. Some of the enhancements and the holograms and some of these other features may be doable, but they're not going to be doable under the current rate that's being charged for the photo card. It's just, it's unrealistic to think that you're going to get all the bells and whistles and still, you know, get the basic line what a photo ID card's all about. So certainly the Bureau is willing to have those discussions, and you know, the industry can look at whether it wants to sponsor legislative changes to facilitate some of those changes that are going to require the changes in law to get there. So, but having said that, we do have some improved versions that are out there that individuals can certainly get at this point in time, and beyond that, we want to continue to have the dialogue.
You're looking at me for comment. There has been a great deal of criticism brought forth regarding the pocket ID card and the license card by a very, very small segment of the licensed population. I don't know anyone who, if they read the basic rules, is not aware that they can have a brand new pocket ID card every 6 months if they feel like going and doing that, if their hair color changes. I don't know anyone who doesn't know that. I have heard some fairly substantial conversations about why can't the two things be incorporated into one, but that's not something that you can facilitate anyway because it would require legislation.
Correct.
So if the industry wants to have one document that has a PI license and a identification card, then that's up to the industry, as I see it, to do that legislatively. I don't think it has, you don't have a role in that other than probably ask your opinion about it at some point.
We can provide technical assistance, right,
That's
on
it.
legislation.
I mean, I just don't see where the big problem is. I know where the complaint originates, and I know how it continues to be brought up, but it's a very tiny, tiny segment of our licensee population. These documents suffice just fine, even though I have the old blue card, and I'm perfectly happy with it because I don't never look that young again, you know. It works for me. And I just don't see that it's a problem issue at the level that some folks have tried to portray it.
Well, I appreciate your comment. Again, the Bureau stands open to if there is an interest to have some revisions beyond what we've done so far, which will require legislation. We are certainly open to it. Do I have any other comments from the committee regarding the pocket ID identification cards issued to for private investigators?
I've just out of curiosity, what's the motive or drive behind trying to merge both documents, the pocket card and the identification card?
I can only speculate because it's not an issue for me personally, okay? But I think probably there are individuals who think that it would be easier to have one document to maintain control of. You'll see in my little thing that I wear around my neck when I'm actually out working, the green one is the license card. Okay, looks kind of like this, okay? Then the back side of this is the identification card. What this facilitates, for me personally has facilitated, is going into a law enforcement agency and they can see that I am that guy who's portrayed on this card. I could do the same thing with a driver's license, I'm sure. Okay, but I think that's the only motive. I'm not aware of any other motive other than to have one document. Okay? And I know it can be tied to a lot of other things that you can get that are done that way, but frankly, it's pretty ineffective for BSIS to be concerned about trying to get a new card created every 2 years that has a new expiration date, because they send that out to us here. And this year, they started pushing it to a December 31st, I think, expiration date. My newest document now expires at a different time than it usually did, but everything will be renewing now at the same time. They've all been coordinated.
Oh, synchronized with another
Yeah,
license.
they've
yes.
all coordinated now, so that all of the things I have 3 different licenses or things issued by BSIS, and they now all coordinate to one expiration date. My life's been made easier already. I don't have to worry about March of 1 year and January of another year and December. So I think they've already made a lot of these changes internally that they could. So I have to speculate what the motive is.
Thank you. I was just thinking maybe if there were some issues where, individuals were having, this was impeding them from executing their jobs or running into some issues with, going into law enforcement agencies or whatever
The first
they're
thing you
doing.
got to do is carry it. It's that simple. And I have a firearm permit, an identification card, and a license in one little carrier hanging around my neck, and it's never been an issue.
Well,
People even think you're somebody you're not that way,
I appreciate your feedback. Appreciate
and
it.
just from what has been brought forth to me was just one, again, the original card, there was, when I came onto the Bureau, there was a typo in the name. We corrected that. The darker material kind of overlaid with the photo made it a little bit difficult to see the photo. We've corrected that. The more prominent seal was to try to make it look a little bit more professional, as opposed to somebody who could just go home and doctor it up on their computer type of thing. So I mean, I get some of those things where we're going with it, but the additional changes, like holograms and almost kind of like replicating a DMV driver's license card, I've also been asked about that possibility, which again, it would be driven by the industry's desire for what's on the card. If they're asking for expiration dates, now we're talking a license and not necessarily a photo ID, which requires that document or that identification be replaced every renewal cycle. And anything beyond that, the Bureau is willing to explore, but the legislative changes would be required before moving forward.
Thank you, Chief.
Do I have any other comments from the committee? Do I have any public comment?
Hi again, Jerry Desmond with Desmond & Desmond on behalf of the California Association of Licensed Investigators. And probably to reaffirm what the Bureau Chief said and what Mr. Parker said as a member of the advisory committee, I think we'd want to express our appreciation for the effort that's been undertaken to actually prepare and conduct a survey to assess what members think. And I know that if Francie Kaler was here with Callie, who is a past president and my legislative chair, she would express her own appreciation, but she was taken up by another commitment today. But I think there had been, and what Callie will do would appreciate the opportunity to look at the results that have been obtained through the survey and to see what the situation is and what would be the alternatives, and whether Callie would decide to take action to change the laws if that's the task to be taken. And Mr. Parker says it all with great experience and skill, and we will have to find out whether it's something that we want to change, and whether it's the confusion issue that's come to bear, and whether we're really talking about the license as opposed to the card. That all has to be gone through. But I think it's the Bureau Chief responding to I think being at some of our meetings where she has gone to, and a couple of our members or a number of our members will go up and say, our number one issue is the pocket card. And so we appreciate the effort that's been taken to get to the bottom of it and find out what the real situation is, what people really think in terms of responding to the survey, and what the options are to address it, and whether, as the industry association, we desire to promote legislation to move forward to make the changes to, and what the enhancements would be. So I think primarily we would like to say we appreciate the effort that's been undertaken and the commitment of time and energy to create and disseminate a survey and look at the results. And we look forward to looking at them with great depth and seeing what the options are. So thank you.
Thank you. Thank you. Do I have any other public comment regarding this agenda item? Seeing none. We're now on item 13. So the current schedule, which was adopted back in, when we had our first committee hearing, I can't even remember when now, is to hold a meeting the first Thursday in the months of January, April, July, and October. That has posed some issues with the January and the first of the new year. Also, it did pose some issues for this meeting with just on the coattails of July 4th. And I think we got the great presence of the great attendance today was because most of y'all had to be sworn in today. So we thank you for that. But essentially, we have a new committee, although there are many reappointments or reappointed members on the committee. But we thought it would be appropriate to bring this forth again to see if the committee members are interested in maintaining the current meeting agenda schedule, which is the first Thursday of January, April, July, and October, or would like to know if another one would like to be proposed. And so now I turn it over to the committee for your thoughts.
Chief, I believe that if you were to move this to the second Thursday of the months, probably maintain the same months, but you would likely avoid most holidays that have been impacting us. I mean, I don't remember, I think it was last year we almost hit Easter dead center, and we've had New Year's, and we've had all of these, 4th of July. Last year, I think we were here like a day ahead of 4th of July or something. Yeah. So I think that's what's been complicating it, and I think if we move to the second week of those respective months, we would probably or avoid those kind of conflicts for the most part.
Any other thoughts?
I agree. I'll make a motion to move the meetings to the second Thursday of January, April, July, and October.
Do I have a second to the motion? Second to the motion? Okay, so I've got a motion. Does the committee have any other additional comments regarding the motion brought forth of the second Thursday of January, April, July, and October? Do I have any public comment regarding the proposed revised agenda schedule? Seeing none, the motion before the committee is to hold our hearings quarterly the second Thursday of January, April, July, and October. Call the roll.
Simon Cruz.
Aye.
Marcel Egley. Sandy Harden.
Aye.
Matthew Lujan.
Aye.
Aaron Riley Parker.
Aye.
Tim Westfall.
Aye.
Todd Inglis.
Aye.
Douglas Lee.
Aye.
Lynn Moorfield.
Aye.
Nancy Mirisch.
Aye.
Javier Gonzalez.
Aye.
A total of 11 yeses.
So the motion passes unanimously. So now everybody's going to have to go home and update their calendars so that we're all knowing we'll be here the second Thursday of the month. So we're now on item 14, which is public comment on items not on the agenda. Do I have any public comments regarding items that are not on today's agenda? Seeing none, we're on item 15, which is now to the committee, future advisory committee meeting agenda items, and this basically involves for the folks that are new to the committee where we just go across the dais here and ask individuals if there's any particular topic or subject as it relates to the Bureau, not how to make lasagna, but how it relates to the Bureau, that, you know, that you would like to see on future agenda items. We'll go ahead and start here on the left. Commander Wood. Unlicensed. So expanding on the discussion of unlicensed locksmiths. Over on this side, Simon.
I would like to, regarding the baton licenses, if there's something the BSIs can look into getting people to recertify either biannually before, if they're renewing it. Retrain, refresher course, pretty much.
And you are aware that that would require legislative change? Okay. Javier?
I'd like to see an update on legislation since what's anything that got signed or vetoed or by the
That's
government.
right. It's going to be a busy time.
Yep.
Yeah, unlicensed activity is always an issue, to sort of check in on that with each industry is great. And then, you know, specifically Senate Bill 468, by the next meeting, I think a lot would have happened with that.
Well, by the next meeting, we will know either it's going to be going to the governor or not, because the legislative session ends the end of August. And so we will have the next meeting in October. Potentially, if it had gone to the governor, we may have a governor's decision by that time, or actually we should. If it goes to the end of August, we should have the governor's decision on the bill. So definitely we'll have an update. Again, as you know, the version of the bill right now, it's been sitting there since last year, and it'll probably come out with some changes very shortly.
Okay, good.
Thank you.
I'd like to discuss the possibility of forming a committee work group for the revision of the firearm training manual, and circle back, or actually start the conversation. It's been on the agenda previously, discussion regarding online training for the initial training for security guards, the power to arrest, and weapons of mass destruction training, the validity of allowing people to do that online. Thank you.
Good, okay. Do I have any comments from the public regarding the committee's suggestions for future agenda items? Brian, I don't know if your mic's on. I don't know.
How's that? Is that better? There we go. I'd like to expand that into enforcement on the training side for licensed companies to be able to train, and some sort of enforcement action against PPOs and training facilities who do not follow the guidelines. It's often now, in the last year since I have begun back in the trenches again, that I'm seeing officers come in who have received 40 hours worth of training certificates, having only been trained less than 2 to 3 hours. We're starting to see that happen more and more, and I'm seeing certificates that are signed by people in positions that they weren't in 10 years ago when the certificate supposedly took place. I think we need to really look at our industry as far as the training goes and put some teeth into the enforcement action against it. Because a guard is certified doesn't mean he really should be out there being a security officer.
Thank you. Thank you, Mr. Baker. Do I have any other public comment regarding this agenda item? Seeing none, do I have an motion to adjourn the meeting? Do I have a second?
I'll second it.
Call the vote.
Simon Cruz,
Aye.
Marcel Egley,
Aye.
Sandy Harden,
Aye.
Matthew Lujan,
Aye.
Aaron Riley Parker,
Aye.
Tim Westfall,
Aye.
Todd Inglis,
Aye.
Douglas Lee,
Aye.
Lynn Moorfield,
Aye.
Nancy Mirish.
Aye.
Javier Gonzalez.
Aye.
11
to 0. Noting the meeting time, 2:16. Adjourn. Thank you all.